Hi, good morning to one and all. Just a bit, can you just give a confirmation that the sound is clear? That's it, and we start beginning with the marathon. Okay, is my audio clear? Yes or no? Okay, so today we'll be starting with the JIGL marathon, which is for the June session, and it is going to be very interesting. And till the very end, you'll have to sit. I assure you, I'll be covering all the important parts. Whichever chapter we are covering, you won't have to do anything else then. I want you in the marathon, I want you all to take a notebook where you all will note down the points. I have my notes which are made from the study material, but I will be going fast. So you need to have a book and a pen, or maybe in your modules you can keep marking. That's the first thing. I'm going to tell you what all materials that I have. One is the study material from ICSI. Second is I have the past exam scanners which I have made. Okay, which has all the past year exam questions. Okay, these are all your exam questions in order. So I will be doing the exam question. Moment I finish a chapter, I will cover all the exam questions with respect, whichever has come in December 2021. All the past exam questions with respect to that chapter will be covered. That's the second thing. And third, what I'm going to cover is the supplement. It is the ICSI supplement which was issued in June 2020 for the June 2022 attempt. Okay, so that is the three things that I will be covering. I will be going in the order of your module chapter number 1. So I will finish chapter number 1, and with me you also have to finish chapter number 1. Now this is a revision lecture, so I will be going a little fast. So those who have already studied, for them this chapter with this revision marathon will be very useful. So without wasting further time, let's begin. First, now this is the weightage of the marks. Your entire JIGL subject has around 17 chapters. All the 17 chapters do not have equal weightage. The average weightage of the marks are given, and from common sense you can apply that. We understand that constitution will be for 15 marks, your CPC, etc. I've broken it down into the important chapters as well. So this is the chapter weighted. So by any matrix, कोई भी matrix से देखो आप, these are your 7 important chapters. These are really important chapters which I will ensure that I cover it today. Okay, that's one thing, including the past exam questions, including the supplement. This is one thing. Then there are grade 2 chapters and grade 3 chapters as well. Okay, your paper pattern will look something like this. So you'll have your exams coming up. So this is how your paper pattern will be. You will have all your questions are compulsory. So you have question number 1 you have to attempt. Question number 2, you will get an option. Either you can attempt question number 2 or 2A, and question number 6 or 6A. Okay, this all. Now if you go to see, the average weightage of the marks are for 5 and 4 marks. So each question in your exam are baby questions. So you don't have to worry, you can be very relaxed, because if you know the concept, अगर तुम्हें concept पता है, you will be able to pull off the answer. Till here it is clear, that's the good part. But also you must have noticed your question number 5. Question number 5, they will ask two questions of 8 marks each, which is of 16 marks. So there are few chapters which I will tell you which come for more amount of marks, which you have to attempt for 8 marks. Now this is one part. Before I start into the revision, I want to give you this basics. One very important thing, your exams are starting. You have to understand that a 5-mark answer, you have to allocate maximum 7 minutes. So anytime you see that you have a 5-mark answer, you have to keep your time, you have to time yourself. अपने आप को time करो घड़ी लेके जाओ, take a watch with you and see that within 7 minutes you finish it. In 5 minutes you should be done writing, and in last 2 minutes you should start wrapping up the answer. So if it is a 10-mark question, you will get approximately 14 minutes. Same way you need to follow. So this is a very, very important thing that you have to keep in mind. You cannot keep writing and writing. Now how much to write in a particular answer? एक answer में कितना लिखना है 5 marks का? That also we will see, because I will be doing the questions of the past years along with the answer, model answer which ICSI has prescribed. Now moving ahead, let's begin with your chapter number 1. Okay, it's time for success. When I say time for success means what? We need to have a 100% positive mindset that the paper will come easy, the subject is very easy, I am very confident and I am going to pass with exemption. This is our mindset. Good to go. Yes or no? We are going to rock this subject. It's a baby subject. 5-mark questions only are being asked. We will know all the concepts and we will write. This is the mindset. Paper easy aayega, correction easy hoga, and I am going to clear. So let's begin with chapter number 1. That is your sources of law. Okay. So good to go. Can we start? Yes. So we're going to start with sources of law. You need to complete this with me. Okay. Now the sources of law is a really simple chapter. It has only 3 parts. Sources of law has only 3 parts. One is the meaning of law, where they have given you 5 schools of thought within this. Okay. The first part of your chapter is the meaning of law. It will give you 5 schools of thought. Second part is going to tell you कि law बना कहाँ से, the sources of law. Sources of law, from where did we get? From the customs, from the judiciary, etc. So we will see the sources of law. And third is the dirty little part, which is your legal theories. 6 legal theories, and I will show you a technique to remember this legal technique, these theories also. There are 6 legal persons they have given you, those theories which we will see. So 3 part. The first part we will start is with the meaning of law. The second, the 5 schools of thought I told you in meaning of law. So there is going to be the natural school of thought, the positivistic, the historical, the sociological and the realistic school of thought. Now wait a minute, 2 minutes रुक जाओ, अभी ही तुमको मैं लर्न कराऊंगा. तो right now you will learn it. First, the natural school of law. What are we doing? We are trying to understand the definition of law. What is the definition, meaning of law? Can you all message in the chat box what according to you is the meaning of law? According to you, what do you mean by meaning of law? What is law? Now can you all message what do you all think is the meaning of law? Yes. So everybody will give different answers to the meaning of law. Same, there is a joke. एक joke है. They say कि जितने jurist है उतने definitions होंगे. How many ever jurists are the legal philosophers, legal thinkers like you and me. How many ever legal philosophers are there? That many definitions will come. Now our definition is not that important. We need to understand the definition given by the stalwarts, the father of law, etc. Now, first way, what do you mean by law? The natural school of law. Natural means what? By God. Whatever God has made, that is the law. This is one view. Now, I'm not going in detail. I will go in detail later on, but I want you to learn right now. Natural means what? By God. 1. Positivistic. Easy word is tough. Is it an easy word to remember or a tough word? So it is a tough word. It's tough for me also. Pay attention. Whenever we use the word positivistic, and I will ask you towards maybe after 1 hour, I will ask you what does positivistic mean. And what I'm telling you now, you have to message in the chat box. Positivistic means the command of a sovereign. Positivistic means what? That there will be a king, and whatever the king says is the law. So first said natural means God. Positivistic means tough word, tough. Remember, sovereign. Sovereign is the king. So whatever the supreme body, supreme person has said, that becomes the law. Third, historical. Historic history. Whatever is being followed from many years, whatever is a custom, becomes the law. Third, sociological. Whenever they use the word, now see these two things I will ask you ahead also. Positivistic, you have to tell me it means sovereign, command of the sovereign. जो भी supreme person leader ने बोला वो हो जाएगा. Whatever the supreme leader has said, that will happen. In North Korea, if Kim Jong-un says everybody should shave off their hair, that will become the law. So command of the sovereign. Next, sociological also I'll ask you in future in 1 hour. Sociological means law for social control. Now understand. Sociological means society. That you are an individual. You live in a society. So there are individual rights, there are public rights. How to maintain control in the society, that is given sociological. They talk that law is to maintain peace in the society. It's a tool for social control. And third is your realistic school of thought. Realistic means what? Be real. Whatever the courts nowadays are saying will become the law. Whatever the courts have interpreted, that will become the law. Till here it is clear. So natural, God. Positivistic, tough word. Tough word means command of sovereign, king. Whatever the king has said, that becomes the law. Third, historical. Historical means past. Whatever is a custom is the law. Sociological. Sociological means society. Law is made as a tool for social control. Realistic. Be realistic. Today nowadays, whatever courts are interpreting, that becomes the law. Generally, you understood. I have not explained the concept yet. Two things I will ask you, positivistic and sociological. Only two things. You should be able to tell me. This will be in the last part of the chapter. Next. Then comes sources of law, from where law has been made. Very, very important. We will be coming to this towards the end. This is the second part of the chapter. The first part of the chapter is all your different schools of thought of law. And third is the dirty little part. I don't know whether you like it or no, but the language is very tough. For that, you require a technique. So, Professor Hart, he talks about primary, secondary laws, which all we will see. Right now, I'm just taking you through the summary of the chapter. John Austin, if he's saying command of the sovereign, which theory is he following? Can anyone tell me? If he's saying command of the sovereign, which kind of thinker is he from the legal theories? Please message on the group. Please message in the chat box. If he is saying that it is command of the sovereign, then which legal theory is he following? He is following the, remember, positivistic. I told you I'll ask you in future, you should know. Positivistic means command of the sovereign. Next, Kelsen talks about a grand norm, which we will see. A grand norm means there is a book like the Constitution and all the laws are following from it. Kelsen talks about grand norm. Grand norm means what? There is a parent law from which all the other laws are made. Then Rocio Pound talks about sociological jurisprudence. Can you tell me sociological jurisprudence? Rocio Pound means he is following which theory? Sociological jurisprudence. Remember this other part which I had said to remember? Sociological means social control. So this, mostly if you remember these parts, will be easy. Then again Salmon speaks about administration of justice and Bentham talks about 8 aspects of law. So this is the summary of the chapter. 3 things: different definitions, sources of law, and different theories. Now let's go with each of one of that. Okay. Firstly, I am going to cover only the important parts which can come in your exam. So it's not something which I will go in detail which is not important. So only which I feel is important from exam point of view, which will hit in your exam, I'm going to talk about that. So firstly, meaning of law. What do you mean by law? Generally, law, there is no unanimous definition, there is no common definition. People believe it's rules, regulations, etc. Then I told you the joke that lack of unanimity, different people, so there is no common, uniform nahi hai. Matlab, there is no unanimity, single definition. As many jurists are there, जितने भी thinkers हैं, उतने definitions मिल जाएंगे तुम्हें. So we have to narrow down to 5 broad schools of thought. So let's see the first one quickly. I'm going to tell you certain keywords. You need to write it in your book, which will help you click. First, natural school of law. What are the keywords to remember in natural school of law? One is law of God. I told you natural means God, whatever God has said is come through law. So you will get your religious scriptures from where the law is derived. One, justice. Okay, and inherent right. Now understand, they will talk about justice because obviously when God is giving law, he will be just. And lastly, there are certain birthrights. You and me have certain natural inherent rights. Inherent means what? From the very beginning we believe we have this. Can anyone give me in our constitution what are these inherent rights called? In our constitution, what are these inherent rights called? Can you all tell me? Very good. So these inherent rights are called as your fundamental rights. Fundamental rights. So your Article 14, Article 19, Article 21 have largely been inserted and covered from the natural theory of law. Okay. So 3 keywords: God, justice, inherent rights. Let's see. First, the natural law is also known as the moral law, divine law, law of God, law of reason, law of nature, universal law, unwritten law. Okay, this is all you can write. Once you know the keywords, then you have to just build the answer. Natural law, that certain laws are inherent or inherent rights by virtue of the human nature and can be understood universally through human reasons. Understand? For example, can anyone message me what is this Article 14? What is Article 14? Can anyone message? Exactly. That is your right to equality. Right to equality. Now, don't you think, तुम्हें नहीं लगता कि equality तो होना ही चाहिए, ये तो basic right है. This is a basic inherent right. Agreed or not agreed? Basic right. Inherent right. This is what they have given here. See, natural rights says that certain rights like your freedom of speech and expression, right to life are inherent rights, are birth rights by virtue of human nature. Just because you are a human, automatically you will get freedom of speech and expression, right to life, etc. And it can be understood universally through human reason. Till here it is clear. So natural law is a universal law common to all humanity. Okay. Now, one we spoke about God and fundamental rights, inherent rights. Then I told you to talk about justice. Whenever we're talking about natural law, we are also going to talk about 3 keywords were there: God, justice, and inherent rights. Now, justice is the main element of law. Obviously, justice means what? Just means to be equitable, another word for justice, and good. It is the highest reason implanted in nature. This is the highest level of reason, birthrights or logic implanted by nature. So nature believes that everything should be just and fair. Now the standards of what is just and unjust, law will define that you can do this, it is good, you can do this, it is not good. Okay. Now in all these definitions, the Romans, justice is the main and guiding element of law. Now even if you go to see in our Hindu scriptures and in ancient Hindu law in India, justice and fairness is the main element, which they called. Can anyone tell me, in Hinduism, justice is a part of dharma or no? Dharma, it is your duty to be just, no matter what. Agreed or no? This is what is there in Hindu law, which is the base. Okay, the main ancient Hindu views that law is a command of God and not of political sovereign. So as we know that this is a natural law, means it is a command of God. Okay, everybody including the ruler should obey it. Law is a part of the dharma. Okay, being just is a part of your duty. The idea of justice is always present in the concept of Hindu law. Okay, then again we can elaborate further whenever they are asking the natural school of law. Then we are going to talk about, after we spoke about Romans, they are focusing on justice. Then we have a Hindu law. Now we are talking about Salmond. Salmond is again talking about justice. Now how is he framing? Answer कैसे frame करना है? So I want, once I finish a part, I will give you the mind map for it. Mind map means what? You will be able to recollect the points. First, what he said, Salmon, he's बहुत अच्छे से रखा है उसने, बहुत ही nicely is portrayed. Read the language. They are saying that the state, in which state you all are living, can you all put in the chat box? Isn't it the duty of the state to give justice and fairness to all? So the body of principles applied by the state in administration of justice is called as law. Means whatever the principles the state is applying to administer, to give, to impart justice is called as law according to Salmon. So again they are talking of justice only. Further, they go on to tell about rules recognized and acted upon by the courts of justice. There are two main factors of the definition. First is you should know the purpose of law. Every law, they call it purpose. Sometimes we call it as the object of the act. Have you heard object of the act? Every law by default will have a purpose that it is going to fulfill. Whether upliftment of women, whether collection of revenue, whether ensuring social peace, etc. Second, once you understand the object of the law, then understand the nature of the law, and one should go to the courts and not to the legislature. Now, legislature means the parliament has made the law. After they have made, you need interpretation, you go to the courts. This is what he's saying. Lastly, has described as a set of rules imposed and enforced by the society with regard, so what has been enforced by the society with regards to attribution and exercise of power over persons and things. So whatever law is, where you have there are certain rules made for persons and things like your property or your individual rights are law. Now the good thing is we finished the first part, and now in the first part I'm going back to this. So your first exam question that can be framed: write a short note on natural law. So what all will you write? So this is once and for all, you will finish it. Three keywords you have. You will write the natural law means the moral law, divine law, etc. It is can be written. It's unwritten. Whatever God has given is unwritten. Second, there are, now see the language, okay? अभी obviously मैं भी हिंदी में बात कर सकता हूँ, but you can't write in Hindi. You cannot write in the Hindi in the exam, right? You're going to write in English. So you also write in correct legal language. Natural law says that certain rights are inherent by virtue of human nature. Just by you are a human, you will get certain inherent rights. So first you give the definition, then you talk about inherent rights, then you think inherent rights means what? Fundamental rights. Directly come that Article 14, 19, 21 have can be said that they have been derived from the natural school of thought because they are your birth rights. Then once we talk about God, then we come to justice. Then we write justice is the main element. Then we will say justice means what? Justice means what is equitable and good. Then we go on to say justice in Hindu law. In Hindu law, they say that justice is a part of your dharma, of your duty. That is given in the Hindu law. Then you go to Salmon. Salmon, again, when he comes, his language is here. बहुत ही high language है. The body of principles recognized and applied by the state in administration of justice is called as law. There are two elements. Go to the object of the law, purpose of the law, and try to find out its true meaning. If you want to understand the interpretation meaning of law, go to the courts, is what they have said in the first part. Till here it is absolutely clear. If they ask you natural law, you will be able to write. Now we'll go to the second one. Now we are going to the second one. The second one talks about positivistic theory of law. Again, positivistic means what they must be talking about. Positivistic, very difficult word. I told you it is a command of sovereign. Till here it is clear that there is a supreme person who is telling you what to do and what not to do. Positivistic. Remember John Austin, positivistic theory, Kelsen, positivistic theory. Positivistic means supreme person giving the command. Now, in this there are two things, John Austin and Kelsen. There are two things, John Austin and Kelsen. John Austin, what is he saying? So this is how John Austin looked. So he's angrily looking. Why are we zooming on his face? So directly go to what he is saying. Okay, this is it. So John Austin is saying that law is a command of the sovereign. It imposes a duty and is backed by a sanction. We'll understand three important words: sovereign, duty, and sanction. So let's go to it first. And when you go to Kelsen, he talks about a grand norm. He talks about a grand norm. Okay. And can you tell me grand norm, which is that school of thought which talks about grand norm? Grand norm which talks about school of thoughts. So here Kelsen talks about the grand norm. Okay, he's also a positivistic believer. School of thought. Okay. Now let's see. Kelsen talks about law is a normative science. What is normative? We'll understand. It is concerned with what ought to be and it is derived from a grand norm. So keywords: normative science, what ought to be, what not to be, and grand norm. So धीरे धीरे आएंगे, slowly we'll come to it. First let's finish with this guy Kelsen. Okay, so let's finish the Kelsen part. Okay, first positivistic. Positivistic means there will be a sanction, etc. Command of the sovereign. John Austin is a positivistic thinker. Now, what does he say? Very simple, okay? Now, if I tell you in North Korea, who is the head in North Korea? There is Kim Jong Un. I'm sure I'm getting this spelling wrong, but Kim Jong Un. He is the ruler, okay? He is the king. Whatever he says is the law. So According to him, law is a command, a order of the sovereign. Sovereign means what? The supreme person. If King Jong-un today says that everybody will wear pink, tell me, in North Korea, everybody will have to wear pink or no? Yes or no? If King Jong-un, he is given a command that everybody has to wear pink, will everyone wear pink or no? Answer is yes. So it is the duty of every person, every subject, every citizen to follow the command of the sovereign. But let's say someone comes and says, no, I will not wear pink, I will wear blue. I pink girls wear, I will not wear. So then for him, King Jong-un will order punishments. Okay. Sanction means a punishment. Till here it is clear. So sanction means a punishment. Austin said that law is a command, order of the supreme person. If he gives a command, it is your duty to follow, and if you don't follow, there will be a sanction. Sanction means a punishment. This I want you to fix it in your memory because I will ask you again. मैं तुम्हें आगे पूछूंगा कि sanction का मतलब क्या होता है. Sanction means what? It means a punishment. Till here it is clear. So there are the three elements of law. Kelsen gives the pure theory of law. Okay. Now this was the first keyword. This was the first keyword to build your answer. But John Austin had something more to say. He had something more to say as well. Let's go to the next one, which is Austin said that law is a normative science. Normative science means there are two kinds of sciences. One is a natural science which says how things are. Ki population is so much, crime rate is so much. It gives the is scenario. कि ये ऐसा है. This is the scenario. This gives you the facts. Tell me one thing. Is law only about facts, or they give you what is to be done, what ought to be, what ought not to be? So legal norms, so all the laws are ought norms. What you have to do. Helmet पहनना जरूरी है. Your tax pay karna zaruri hai. So this is the normative science. Crime will be specified that you cannot do this, you cannot do XYZ thing, you cannot deal in drugs, you cannot go killing. So it goes on. Law is a normative science. It tells what ought to be, what ought not to be. Law does not attempt to describe what actually occurs. Law doesn't say what is the situation. It is gives you rules to be followed so that we can have a better society. And all norms derive their power from the ultimate grand norm. All the laws derive their powers from the ultimate grand norm. Okay. Now, and grand norm was given by Kelsen, which we will see later part. So according to Kelsen, law is a normative science. He explains what ought to be, ought not to be. Then it is derived, all laws are derived from the mother of all laws. Like in India, it is called as your constitution. Now moving forward to the historical school of jurisprudence. History, past, background में जाओ, what is law? So historical school of law of jurisprudence talks about custom, that law जो है वो custom से आता है. Today we have the Hindu Marriage Act, we have the Muslim law. All of them, this law बना कहाँ से? From where these laws came? It all were passed from certain customs. So history means go back to the customs. So F.K. von Savigny is a founder of the historical school. So this guy is so if they ask you this question, you will write this: Savigny is the founder of the historical school of law. According to him, law is found, not made. Obviously, customs तुम ढूंढोगे क्या है. In any place you will go and find out what are the prevalent law practices that people are doing. That will only become the law. So you have to find what is the law, what is the custom, and accordingly to that custom will become the law. So first there will be custom or there will be a law. Quickly, can you all message in the chat box? First there will be customs or there will be this. First there will be customs or there will be a law. So very first thing, first customs will come. You find which are the customs, and if the custom is lawful and it is rational and it is legal, it will become the law. So which precedes the law? So can I say custom precedes the law? Answer is yes. Legislation is a law process in law making. So when we make the law, it is just a procedural part where the customs are getting a legal force. So let's go how it is given in your module. First, historical definition of law. Savigny has summarized as below. His theory of law has been summarized as below. First, historical means what is the key word? It is what is the key word? Customs. Now from customs you will say that customs are found. Okay, that's how the law will be made. And you cannot make a custom. Okay, law is found and not made. Second, law making is just the last part. Customs is the first thing and then the law making will come. So we can say that uh, the customs come before the law. So legislation is just the last part of making the law. Law is not universal in nature. Like language, it only varies with people, and very good. See this. Now law, they are saying, is coming from customs. So first is customs, then is law. So that means in every place there is a different custom. Geographically, you go in different continents. In Africa, custom will be different. So law, since customs are not universal, law will also not be universal. In abroad, we can have bullfighting and all those things. Okay, in India, it might be different. Same way in abroad, there might be so many laws which are valid, but in India we will not allow because our customs, our philosophy, our culture is different. Like languages, it varies with people. Customs not only precedes the legislation, but it is superior to it. Okay. Now we are done with the historical part, customs and all those key points. Now we are coming to sociological school of jurisprudence. I told you, whenever I use the word sociological, matlab the law is made for society, for social control, for benefiting the society, etc. So the main subject matter of sociology is society. Idea of sociological school is to establish a relationship between law and society. So they are focusing, their entire world rotates around society. Everything rotates around society. So the main subject matter of the sociology is society. They try to bring a correlation. So idea of sociological school is to establish a relationship between law and society. So law and society में connection लाना है. क्या connection हो सके? What could be the connection between law and society? Can anyone message and tell me? What is the connection? Answer is very simple. That laws are made for social control, that everyone behaves normally in the society. Imagine other way around. If there were no laws, अगर कोई law नहीं होता, imagine what would be the state of society. Will people follow traffic laws? There will be theft, there will be so many crimes. So law ensures that the human behavior is controlled. Okay, so law is a means of social control that satisfies human wants. Law is essentially a social fact. Everything about society. Clear? So let's highlight the keywords and move ahead. Sociological definition of law. So Duguid defines law as essentially and exclusively a social fact. Now pay attention. It's very simple. I can say law is a social fact. But we have to develop. Now my English was not good. मेरी इंग्लिश सही अच्छी नहीं थी, बट मैंने इम्प्रूव किया. आई इम्प्रूव्ड इट by learning languages, building my vocabulary, by reading these books. See, we know law is a social fact, but how are they saying they are essentially and exclusively? These are adjectives. ये थोड़े words है. डालो तो थोड़ा ऐसा लगता है कि it's very well read. So law is essentially and exclusively a social fact. Iring. Okay. So we understood the concept, but the language is also important. Iring defines law, the form of guarantee of conditions of life assured by the state's power of constraint. Bouncer, what does it mean? Same thing, that by the state's power of constraint, state has a power to constrain things, stop things, control things. So constrain means control. So today we can say that the government has an iron fist. If you do anything wrong, they will crush you, they will put you behind bars. So because of the state's power to control things, we get a guaranteed conditions of life. We have a mental peace that government will handle. So we get a guarantee standard of living, conditions of life. So that is about sociological. Language you need to learn. Once you understand, you can write in your own words. But the more legal language you learn, the better your answer will be. There are three essentials of the definition. Now, what are the three essentials? First, three essentials in sociological. First is social control, social purpose, and it will be forceful in character. Again, what does it mean? Three essentials. सबसे पहला essential की social control. That society, we've done that. Okay, law is merely a tool for social control. But why are we controlling? So there has to be a purpose. I told you every law will have a purpose. I'll give you an example. Can you play loudspeakers after 10 p.m.? There is a social control. Government has banned loudspeakers after 10. What is the purpose? So that people can sleep well, have a mental peace of mind and sleep. Okay? But I say नहीं, आज तो पार्टी होगी ही. 4 बजे तक पार्टी होगी. आंटी को पुलिस बुलाने दो. चलता है ऐसा? Is that okay? Answer is no. So it has a forceful character that आपको सुनना पड़ेगा. You will have to listen. You cannot play just because it is your birthday. It is forceful. Yes, you have to be silent, peaceful after 10 p.m. So three things: social control, purpose, and it is forceful or coercive. These laws are सुनना पड़ेगा. Okay, you will have to listen. Rocio Pound thinks that law as a social institution satisfies social wants. So the main purpose of law is to ensure that society is well maintained, and claims and demands exceptions involved in the existence of a civilized society. So we want everyone to be civilized, mannered, well mannered. For that we have laws. Okay. Then so we are done with this theory also. Now coming to the realistic school of thought. Realistic is in come on yaar. It's all by the courts. Be real. Courts today, whatever they are interpreting, that is the law. If courts today have said that you cannot do XYZ and they interpreted that this is right, this is wrong, that becomes the law. We've heard of something called as precedence, judicial precedence, which we will come later. मतलब ये एक part है, judicial principle, extremely important, has come so many times. I've seen the past exam questions and that is one of the most important. Okay, so realistic school of thought, remember courts, be real, courts are passing. So how we word it? Law is enforced through courts. Law is a mechanism of regulating the human conduct of society. Okay, but everything is the courts interpret. They give certain landmark judgments called as precedents, judicial precedents, which become binding. Okay, and realistic definition of law. Realistic definition of law in terms of judicial process. Let's see, realistic. Law is defined in terms of judicial process, that the law judiciary will define, interpret what the law is. Okay, whenever there is a confusion, and we have a chapter also, interpretation of statutes. Who interprets the statutes? Can you all message and tell me who interprets the statutes? The court. So it is a judicial process. Law is a statement of circumstances in which the public force will be brought to bear upon through courts. So again, very simple, it will be brought by the courts. Those who are not following the law, there will be punishment, and law will define your rights, etc. Okay, a principle or a rule of conduct as to justify a prediction with reasonable certainty that it will be enforced by the court. Today, you go and see in media, you go and see anywhere, people say we have faith in the judiciary. That even if something wrong has happened, कुछ गलत भी हुआ है, they believe that, you know, the justice will be provided. We can predict that सही ही होगा. That in the end, no doubt, it is a slow process, but it is a very bottle tight process where we all believe that the judiciary will give justice. So we can predict with reasonable certainty that the law will be enforced and the justice will be given, and the rules of conduct will be decided and established. Okay, now the state, in order to maintain peace and order of the society, formulates certain rules of conduct to be followed by the people. These are called as laws. Now again, a very simple definition you could say, or simple sentence: the states, in order to maintain peace and order in the society, formulates, now see the language, formulates certain rules of conduct to be followed by the people. These rules of conduct are called as law. Okay, now this is a summary, not very important. In this, they are going to give you, so I have finished the 5 schools of thought. If you've understood it, please be very happy, positive that you've understood it, and highlight the keywords. I hope you're highlighting the keywords. If you're not, from now on you highlight the keywords. Okay, now law, again, in very small, it is not expected to come in the exam, but very simple, easy part, so we'll do it. Law can be called as mandatory laws, positive, prohibitive laws, and permissive laws. Okay, so there are 3 divisions of law. First, you tell me the law to pay your taxes on the due date is which law? Mandatory, prohibited, or permissive? Mandatory means करना ही पड़ेगा. You have to only do. So it will come your payment of taxes which are obligatory, mandatory for a person to pay. Like example, payment of tax, wearing a helmet, wearing a seat belt. Okay, these are all mandatory laws that you have to only do. If you want to go abroad, you have to get your COVID test done, that RT-PCR. So mandatory nowadays. So that's a mandatory obligatory law. Prohibitive, कि ये नहीं कर सकता. Tell me one thing. If I want to take a AK-47 into the school, he will say no, it's not allowed. It's a prohibited act. You cannot carry sharp weapons, etc. in airplanes, etc. It's prohibited. Third, permissive is where it is, law is not obligatory नहीं है, mandatory नहीं है, rights दिए, permission दिया हुआ है. तुम चाहो तो करो या नहीं करो. It's a permission granted. You either do or not do. For example, right to marry and right to vote. So it is a right, okay? So if you want, you find the real person, your soulmate. Let's say you've completed your CS and now it's time to settle down in life, and you found someone who's your soulmate. So you will decide to go ahead and marry. So this is your permission is given law to go and get married. So very simple. Let's go to the next one. Now significance of law, not very important from exam point of view. Now coming to the second part. So we finished from three parts of the chapter. First part is completely over. Okay. So you can be happy about it. Second we are going to start is your sources of law. Where are the different sources of law? And it has come so many times in the exam, so many times that you better get a book and pen and start writing it down and finish it with me. I will tell you also what has come 100 times in the exam. First, so this is your flow chart, that sources of law. Right now I'm not telling now, slowly it will come. So sources of law divided in two parts, primary and secondary sources. Primary are your most common ones, that is your customs, your statutes, your judicial precedence, and your personal laws. So these are your primary sources of law. In secondary sources, there is justice, equity, good conscience 1, and English law, which is 2. In English law, you have again common law, mercantile law, principles of equity, and statutes. Till here it is clear. So this is your what we are going to do. Okay. Then when we start customs, from all of this, the most important is your customs. India is a country full of customs, full of different cultures. So, and lot of customs have become law. In customs also there is further segregation. I'll show you the flow chart for that. Okay. This is the flow chart for customs. Like when you go in customs, customs have without sanctions and customs having sanctions. Now in the start of the video, I had asked that one vocabulary question I had asked I told you all to learn. What do you mean by the term sanctions? What do you mean by the term sanction? Can you all message in the chat box? What do you mean by sanctions? Okay, got it. So sanctions means punishment. Now customs without having sanctions and customs having sanctions. In customs having sanctions, they've given you legal and then they've given you conventional. In legal, there is further division of local and general customs. In local, again they've given you geographical and personal, which we will see slowly. Now let's start. Customs may be divided in two parts. We've seen what was the two parts. One was having punishments, without having punishment, and one is with having punishment. Quickly let's go to the point. Okay. Now customs without sanction means it is an option to follow that custom. If you don't follow, you will not have any punishment. Means it is a without punishment. No punishment if not followed. If not followed. Clear? Now, for example, a custom to follow this baby shower, this haldi ceremony, etc. A custom is to say namaste, but this is not mandatory. So you will not have any punishment by law. So these are just discretionary customs. These do not become the law. So this is not a law. Though it is a custom, but it is not mandatory. Even we see the Raksha Bandhan. It is a custom from many years, but it is not compulsorily to be followed. Now we are going to see, we are concerned with customs which have a sanction, which have a punishment if that custom is not followed. And that becomes a law, right? So customs having sanction. These are enforced by the state, because if you don't follow, you will have a punishment. Now this can be further divided into legal and conventional. Legal means by law, has been passed for that, and conventionally means it's a tradition or by contract law, etc. Through many years it's been followed and it has come. Okay, we will see. First, we will start with legal customs. Now, legal customs are customs which operate as a binding rule of law. They have been recognized and enforced by the courts of law. There are of two kinds: local customs and general customs. So again, legal customs could be local and general. Local means what? This is a custom which is followed locally. If you go in certain panchayats or in certain villages, they have a certain culture to be followed which is limited to that locality. For example, okay, this local customs could be geographical customs or it could be personal custom. So if it is restricted to a territory, that only in this village we follow this practice and mandatorily it is to be followed, the sarpanch or the panchayat have decided that. So that becomes a geographical local customs. Personal customs is what? As your personal belief, personal maybe religious belief. Okay, so this personal belief, wherever you go, you will take that custom with you. For example, if we have whatever religion you are following, if you go in another country, you will follow your custom, you will take your customs with you. Okay, now local customs which prevails in some definite locality, but there are certain sects or communities which take their customs wherever they go. They are called as local customs. Local customs are of two kinds: geographical and personal. So let's take an example. If you go to see in the Sikh marriages, they have a practice of carrying this a sword, a small knife is carried by them. Okay, and this is in marriages of Sikhs generally. Now this is a local custom that they all follow. If this local customs could be now, even if they go abroad, they will still follow this. So we can say it's a personal custom. It's a personal custom that you are following. Further, if you go to see a local custom, which is territorial in nature, if you go to see in Spain, they have this Pamplona running of the bulls. So that is a local custom in that particular area only. Okay. General customs are, applied irrespective of any territory. For example, your marriages act which are there, the Hindu Marriage Act, Muslim Marriage Act. So that is a general custom followed in all cases, all the territories. Now, conventional customs. Now, if I come to conventional customs, they are with respect to a certain usage over a period of time. For example, the merchants in bill of exchanges used to give 3-day grace period. Now this became a custom. A conventional means related to business. Yeah. Now, conventional customs, yeah, also is known as usages. These customs are binding due to an agreement between the parties and not due to any legal authority. So this is like contracts by agreements between the parties. So somewhere as we have conventional customs arise out of contractual rights. For example, if we say that whenever you entered into a bill of exchange, a normal 3-day grace period is to be given. It is known as a day of grace. It is a custom to be added to add these grace periods. Now, when you go back from here, if you just look here, so this is your structure. Customs could have without sanction. We are not concerned. We are concerned with customs having legal sanctions. Now, this generally becomes the law because if you don't follow, you can have penalty, and law will ensure that it is followed. The state enforces these customs. Now, legal customs could be with respect to a locality, could be geographical or it could be personal, and this is irrespective of locality. It's a general custom. When we talk about conventional custom, it is with respect to a arising out of a contract. It is not imposed by law but by the parties onto themselves. So the parties themselves have bound themselves, so the conventional custom will come. And if there is a breach of contract, then the courts will enforce. Clear till here? Now I'm coming to the most important part of the chapter. Most important part of the chapter. Okay, you can take your break, but mark it extremely, extremely important. Let's see. Requisites of a valid custom. This is super important. Has come many times in exam. Many times in exam as well. And I'll show you. So what are the questions that they frame? Now I want you all to message me. Do all customs become law? Do all customs become law? Do all customs become law? Yes or no? Answer is no. Then what all requisites, what all things are needed in a custom to become a law? So they have given you all those things. ये सब अगर custom के अंदर हुआ तो ये law बन सकता है. So a custom is valid at law and will have a binding force only if it fulfills the following essential conditions. Now what are the essential conditions I'm telling you now, but I'm telling you the number of points. There are 8 points that you have to write. 8 points, okay? So ये सब features होना चाहिए. Firstly, your time immemorial, okay? When I say it should be ancient, okay? Immemorial, antiquity means what? बहुत पुराना, immemorial time, you cannot trace its origin. If I tell you the ice bucket challenge, can it become a custom? Answer is no. You know, abhi aaya hai custom. A custom, in order to be valid, must be extremely ancient. A person should not be anyone, if they can show you the beginning of the custom, is not good to become a law. So this is the first thing. It should be ancient or immemorial. Second, should be certain and finite. Mean there has to be proper rules to it, proper clarity, and everybody should know about it. It cannot be vague and ambiguous. Ambiguous means confusing, unclear. वैसा नहीं, certain, this is the custom. Reasonableness. Reasonable means what? There are certain customs which were followed very clearly and very ancient, but they are against the law. For example, sati. Now it was a practice, or triple talaq. It was that instant triple talaq. We did not find it having place today, so we did not find it reasonable. So then we have not allowed it to be a law. Compulsory observance. That means everyone should have been continuously observed it without any interruption from immemorial, and it is a obligation. Conformity with law and public morality. Unanimity of opinion. The custom must be general or universal. If left to an individual, if it is an option, opinion everyone के हिसाब से, then it cannot become a custom. Okay, so if there is a choice, it cannot become a custom. To become a law, it has to be compulsorily followed. Option cannot be considered as a law. Peaceful enjoyment. It should have been peacefully enjoyed without any dispute anywhere. Consistency. It has to be consistently followed and must not be in conflict with any other established custom or law. So what are the 8 points? It has to be immemorial, it has to be certain, it has to be reasonable, it has to be compulsorily followed, it has to be in conformity with the law and public morality, unanimity of opinion, peaceful enjoyment, and consistency. Very, very important. Now this is very important. Customs, and when does a custom become a law? So all those 8 points you need to write. Now coming to the next thing, which is your judicial precedence. Now what we are doing is judicial precedence. Very important, and this is also a exam question. This is also a exam question. So let's see what it is. First, precedent. If I say precedent means what? Previous. Yes or no? Precedent means previous. And when I say judicial precedent means what? Judiciary कोई law पहले आया हुआ है. The judges have given some previous decision. So a prior judgment, decision of the court which has been previously decided is called as a judicial precedent. Now, a judicial precedent is when similar facts are there, then we have to follow the precedent, the rule laid down previously. Now with this what happens, अगर facts same है, अगर पहले की court ने judgment pass कर दिया, so even I have to follow. If the facts are the same and I find that a prior court, a Supreme Court has passed on the same facts this judgment, so even I am bound. There is a precedent already set, there is an example already set, I have to follow it. Now question is why? So you have to give some justification. Because there has to be clarity, certainty in laws. Okay. Another thing, inferior courts are bound to apply the precedents given by superior cases. Precedent means there has to be some guiding pattern for the future. Every time you cannot revise judgments. So once a prior judgment is given on a particular matter, similar courts have to follow that judgment. This is a precedent. So in judicial field, it means a guidance or authority of past judgments for future cases. So whatever is the past judgment, it should normally, that judgment will also apply in future. Okay, unless obviously we've seen some landmark judgments which reverse decisions, but normally it should be followed. This is a judicial precedent. Now in your exam, this is what comes. So now this is important from exam point of view. Okay, let's see. First, kinds of precedent. Kinds of precedent. They've given you 4, 1, 2, 3 and 4. They can ask any and explain any 2. First, let's see. They are talking about declaratory and original precedents. Declaratory and original precedent. First, what is a declaratory precedent? What is a declaratory precedent? And what is a original precedent? Tell me, ये दोनों में you all are revising it. So can you tell me which comes first? First the original precedent will come or a declaratory precedent will come? Can anyone tell me? Which will come first? So first will be a original precedent. A original precedent is a landmark judgment. It's a landmark judgment. It is that case will find a new rule, will find a new rule and will lay down a new rule which is to be followed by other courts in future. So this is a original नया judgment दिया है उन्होंने. So a original precedent is one which creates and implies a new law or a rule. For example, of a original precedent in the Council of Environment versus Union of India, a rule was laid down in this case that polluter pays principle was laid down. In that case, polluters pay principle in the Council of Environment versus Union of India. So that became the landmark judgment. The rule was laid down that the polluter should pay. In future, when a similar case will come, the courts will just say that we are using the polluter's pay principle of that original case and we are applying in this case also, and they will pass the judgment. So this is a declaratory precedent. Declaratory means what? It is in a case they will just say that we are applying the original rule. So a declaratory precedent is one which merely applies an already existing rule of law. Clear till here? So in case of declaratory ones, the rule is applied because there is already a law. In case of original precedent, it is a law for the future to be applied. Now tell me one thing, in advanced countries, in all these developed countries, there will be more original precedents or declaratory precedents? ज़्यादा कौन से होंगे? Original precedents or declaratory precedents? So there will be more. Obviously, a developed country must have given all the rules of law must be there. All the courts just have to apply those existing laws. So declaratory precedents are more numerous. Clear? Now coming to persuasive precedents. Now persuasive means a pushy effect, a little bit of forceful effect, but not binding. Not a binding one, pushing effect. Okay. For example, when a High Court of Gujarat, when the High Court of Gujarat has passed a judgment, okay, can you tell me, will that judgment be applicable on High Court of Bombay High Court or Mumbai High Court? Will they have a authoritative precedent, binding effect, or they will say, "Arey, chodo jaane do," or it will have a weight. It will have, okay, fine. So if a matter has come before the Bombay High Court and a case law is cited of Gujarat High Court, where the lawyer is saying that in the same facts the Gujarat High Court has passed the decision in our favor. In similar matter, Gujarat High Court has passed this order. You also please follow. So the Bombay High Court will not take it lightly. They will say that it is of the same footing. We are on the same footing, and our level person has passed the judgment, means it will have good weight and it will have a pushy effect, but not binding effect. I'm not bound to listen by मेरी level का है, मैं reverse करके नया judgment pass कर दूंगा. I can pass a new judgment, but it's not good to pass new judgments on same facts every time. So mostly they will listen to the same level courts. So that is called as a persuasive precedent, is one in which the judges are not obliged to follow. They are not bound to follow, but which will only take into account the consideration and to which they will attach great weight. So they will only take into account those considerations to which they will attach great weight. So they will attach good weight. So a persuasive is not a legal source. It will be regarded as a historical source of law. Means what? Obviously, ये past में ही pass, अगर बॉम्बे हाई कोर्ट के पास में is there the matter, the Gujarat High Court must have already passed where someone is quoting that case in front of me. So it must be a past judgment which someone is trying to tell me, the judge, that see, your level person has passed this judgment. So it is a historical case they are bringing forth to me. The decision of one high courts are only persuasive precedent in other high courts. Clear? Then coming absolutely authoritative precedent. Very simple. If there is a higher court and there are lower courts, if higher court has passed a decision, if the higher court has passed decision, it is binding on all lower courts. Okay, so authoritative precedent is one in which the judges must follow whether they approve it or not. So whether they approve it or not, they have to follow. मुझे अच्छा लगे या नहीं लगे, I have to follow. It's authoritative. Sometimes Supreme Court has passed a judgment as per Article 141. if the Supreme Court has passed any law, all the courts below it has to follow it. It is a binding, authoritative, binding, absolute. Judge's discretion is excluded. You don't have discretion. Judge cannot do anything. He has to listen of the higher court. So every court in India is absolutely bound by the decision of the court superior to itself. All courts in India are bound to the decision of the Supreme Court, as we all know. Then comes conditionally authoritative precedent. Conditionally, conditional. Let's see. Now, as we've seen, a conditionally authoritative precedent is one in which, though ordinarily binding on before that court, it is liable to be disregarded in certain cases. Now see, condition apply देखा तुमने? Condition apply. So normally, when a High Court of Gujarat has passed a decision, we will believe that it is binding on them. High Court of Gujarat has passed the judgment, so we will believe that High Court of Gujarat it is valid. But if in High Court of Gujarat it goes in appeal within the same court to a higher bench, then that is there on that higher bench, they can disregard it and pass it. This is called as conditionally authoritative precedent, where the higher bench, more number of judges can, up to them, they can reverse and pass the judgment. Okay, so let's take an example. If there is a single bench means judge of the Gujarat court which has passed a judgment, it is only conditionally authoritative on the dual bench. So when the matter has gone, so we know in Supreme Court, from Supreme Court where you will go in appeal? You can go in appeal to a higher bench. So we had seen in Keshwanand Bharti case versus Union of India, where the basic structure of the constitution was challenged. In the Supreme Court only it was going in appeal and appeal and appeal to higher benches, still we went to the full bench. So a conditionally authoritative one is one in which, though ordinarily, normally it would have been binding before the court which is cited, but it can be disregarded by a higher bench. In India, a decision of a single judge of a high court is absolutely authoritative to lower courts, but is only conditionally authoritative when cited before a divisional or a dual bench. Till here it is clear. So, two judges are sitting on the same court, then it is just option at me to follow or not follow of one judge who is of the same court. Okay. From your precedents, there are three rules that have been laid down. In your precedents, there are three rules that have been laid down, all very, very important. We'll quickly go through it, okay, which they can ask, and they have asked for 2 marks, etc., to 2 marks each. So first is your stare decisis, second is your ratio decidendi, and third is your obictor dicta. Clear till here? So from precedents, what we did, that the previous courts passing a judgment, there are 3 doctrines that have laid down, 3 doctrines that have come. First is stare decisis. Do you know what it is? Do you know what is ratio decidendi, and do you know what is obictor dicta? Yes or no? It's very important from exam point of view. Very good. Okay. So let's see. Stare decisis means, I'll give you one simple word. When a small child is there, okay, and he's trying to fidget with certain things. So you stare down, you look at him angrily, and you tell him to stop, don't move. Yes or no? Stare means you stare and you tell, don't move from there. Be in that place and sit and study. Wait till the entire lecture gets over. Before that, you will not get up. This is a scare, not a stare, but a scare. You're staring at the child and you're telling them don't listen to what I'm saying. होता है कि नहीं? This happens or no? You kind of telling a person. Same way, how do you connect it here? We are telling the courts today, don't unsettle things. If there is a law, let it go on. Don't every time replace the law, change the law. Let there be certainty in law. So अगर uniformity होगा, एक ही बार rule apply हो जाएगा. Once only the rule is applied, so there will be certainty. People will be confident. People will be able to predict that yes, this will be the judgment and this will be the justice. So there will be more business in India also, because it will become more predictable and easy to do business. Same way, stare decisis, what does it say? That stand by already decide cases. Don't again and again change the judgments. So once a landmark judgment is passed, other courts should follow it. This is called as stare decisis. So if there is another judge, he is thinking, let me make my own, let me reverse the judgment. So rule of stare decisis is telling him, don't unsettle it. Stand by already decided cases. Already precedents are there, follow it. This is what stare decisis is saying. Unless there is an extreme need to change the law. Second, so I hope stare decisis is clear. Now coming to ratio decidendi and obictor dicta. Now ratio means the rule laid down in the case. In rule laid down or the principle laid down in the case. A case can go on for number of years. There can be 100 arguments, 100 sentences that the judge might say, the parties might say. If you read any judgment copy, it can run into 100 pages. 100 page की judgments होते हैं. But tell me one thing, is everything important for future point of view? If I am sitting to research something, I just want the crux of the law. What is the principle rule laid down in the case? So in our law internship also, what they used to say, what is the ratio of the case? What is the ratio of the case? Rule क्या किया था? So for example, they had said, I think I've taken it down. For example, in the Indian Council for Environment versus Union of India, the principle laid down was polluter pay principle. So this becomes the ratio of the case. The ratio. This was the principle that was laid down in the case. Okay? That is the ratio of the case. And obictor dicta means what? Everything else other than ratio. Okay? So, for example, the other facts said by the way, etc. A judicial opinion which is not necessary for the decision. Let's understand. I want you all to message me in the chat box. Is the judge quiet? Judge will be silent throughout the, and only in the last when he is giving the decision he will speak, or in between also there will be judicial utterances. The judges will speak, will ask questions. Yes or no? Will the judges speak throughout also? Yes, obviously. So the judges continuously keep asking questions, keep giving opinions, asking that why you didn't do this, etc. Show me this, etc. Okay. So this all is obictor dicta. This is said by the way. Through the entire case might go on for 5 years, so the judges might have said so many things. But is it necessary it will form the part of the judgment in the main core principles? Answer is no. So that is the obictor dicta. Obictor dicta is all that idhar udhar ka cheez, and ratio is the main thing. So whenever we go, we ask for the ratio. Obictor dicta is when you want to go into that specific case into more detail, then you will see that what all was said in the way apart from the ratio also. Now again, what we said, stare decisis, doctrine of stare decisis, what are the key words? Adhere. So stare, adhere to previous decisions. Don't unsettle things. Let there be uniformity in law. Let there be certainty in law. Principles means that the cases should be like cases, similar cases should be decided same manner. Okay, this is based on public policy because that will only make sense, because if the facts are the same, we can assume that the judgment should also be the same. That is stare decisis. However, exception that is not necessary to be rigid, zaruri nahi follow kiya jaye. If you feel you don't have to follow the rule at the cost of justice, so you don't have to follow this doctrine of stare decisis at the cost of justice, you can definitely pass your own judgment also. We can unsettle things if needed, but it should be used very rarely, sensibly, prudently, and very methodologically. ठीक है, सोच समझ के यूज करने का, सिंपल वर्ड. Ratio decidendi, Latin phrase. Ratio means the reason, the rationale for the decision or the foundation of the decision. To be honest, whenever we are going and we are researching, we just want the ratio. The main principle क्या था, crux क्या था judgment का, the principle that the case has established, polluters pay principle, or we have so many principles that the court lays down, so that is to be followed. Okay, then the underlining principle of the judicial case, which is only authoritative, is termed as ratio decidendi. So which is authoritative, obviously principle hai. So it is going to be used in future also, and it is going to be binding. It is a concrete decision which is binding between the parties. Professor Goodhart said that ratio decidendi is nothing more than the decision based on the material facts of the case. Now let's see what is. Start giving the example of polluters pay principle. You can quote it in your exam as well. So example of this polluters pay principle. There was a case law in Indian Council Environment Legal Action versus Union of India. The ratio of the case was polluter should pay. Now what is obiter dicta? Now the judge obviously doesn't keep quiet throughout the case. He will keep talking, asking questions, etc. All the other aspects of the case also, but not necessarily all those things will have to be in the decision of the case or the judgment of the case. So all the other facts of the case, surrounding facts, etc. can be called as obiter dicta. So it is those judicial utterances in the course of delivering a judgment which were not strictly necessary for the decision of the case is called as obiter dicta. Especially in law, it refers to a passage in judicial opinion which is not necessary for the decision of the case before the court. So all the judicial utterances is not necessary for passing the judgment. These statements may go beyond the requirement of a case and have the force of persuasive precedent only. So even sometimes the judges go outside also, outside of the case, and sometimes have certain occurrences, etc. But those are all casual utterances which is a part of obiter dicta. Okay, they do not become the law. So we had seen precedence, judicial precedence, very very simple. Supreme Court, according to Article 141, all the law passed by the Supreme Court is binding on all the courts below it. So this is your Article 141. This is where decision of the Supreme Court is binding on all. Now coming to High Court decision declared by the High Court is binding on all the courts below it. So we have seen Supreme Court. Okay, so now this is there. Then even in High Court, when you see the same points, it is binding on decision of High Court is binding on all the subordinate courts. It has only persuasive value on other High Courts, as you've seen. And whenever there is a conflict, same number of bench and different courts. So let's say Gujarat High Court of dual bench has passed a decision, and the Bombay High Court of dual bench has on the same fact passed a different judgment. Which will prevail? कौन सा जीतेगा? Gujarat matter or Bombay matter? So answer is whichever is late, whichever must have been passed later will prevail. So when there is any conflict between two decisions of the same bench, generally the later decision will prevail, because the judge would know what is the precedent, but sometimes he still wants to reverse it, so he can do that. Okay, a decision of a bigger bench is binding on a smaller bench. Then comes to statutes. Now all this is not important, so I'll go a little faster on this. So statute is a law that has been passed by the parliament. It is a creation of the parliament. You have certain just scriptum laws which are written down laws, and there are some unwritten laws which are called just non-scriptum. Clear? Then laws could be supreme. You can have the main act, and you can have a subordinate act. Subordinate, as we can delegate the powers can also be delegated. Okay. Now personal laws. Now again, this all is not important from exam point of view. I'll go a bit fast. In personal laws, they have spoken about Hindus and Muslims. In Hindus, they have said that which are the main laws in Hinduism. So they say the Shrutis and the Smritis. Shrutis have 4 Vedas and Smritis have 3 main Smritis. Okay. So let's see. The Shrutis are basically direct words of God, what is heard, whereas Smriti are what those the saints, the rishis have brought in and have remembered. So let's see. First is Shruti. Shruti are direct word of God. It is from what has been said. Now there are 4 Vedas. Can anyone tell which are the 4 Vedas? Rig Ved, Yajur Ved, Sam Ved and Athar Ved. And Smritis, there are 3 Smritis. There is Manu Smriti, Yajnavalkya and Naranda. Okay, so these are all recollection, that is they have memorized and handed down by the rishis and ancient teachings. So Smriti comprises of the Vedic literature which has been remembered. Okay, so this is about Hinduism. If we go and see in Muslims, the main book is called as the Quran. So Quran again is the word of God, and what the Prophet had done and what the Prophet's acts are covered in the Hadith. So Hadiths are the sayings of the Prophet Muhammad. Okay. Then, so these are the two main principles on which the Islamic law is there: Quran and the Hadith. Quran is the book of God, and Hadith is the Prophet Muhammad's teachings. Then comes 3 other things. One is the ijmas. Now, what are ijmas? The opinion of the companions of the prophets. So the Prophet Muhammad companions had certain opinions that were called as ijmas. Qiyas are analogies. So analogy means what? On basis of whatever the religion is there, they will try, the scholars will sit and decide and analyze whether a thing is allowed or not allowed. For example, at the time of the Prophet, smoking was not there. So now there is an analogy that in the Quran it is written that you cannot do any act which is injurious to your own self, which will harm you in little bit or which will cause you addiction. So the analogy is, since that is saying that addiction, anything that makes you addictive, is prohibited. So even cigarettes are prohibited. So it's not given. They have connected facts. These are analogies, analogical deductions from comparison of all these, and then they apply to a specific case when needed. Then digest and commentaries on the Mohammedan law is also there in your Muslim law. Then coming to your secondary sources of law. In your secondary sources of law, the justice, equity and good conscience is little bit important. And the sources of English law is just a read, it's not a very important. So let's read from exam point of view what do you mean by justice, equity and good conscience. It has come in your exam also. If a particular law is already specified and is clear, the judges will not go to the justice, equity and good conscience. If only when a matter is silent, there is unclear activity, only then the judges will go. So justice, equity and good conscience. So justice, equity and good conscience are generally applied when any written law is not applicable to a legal matter. So when there is an absence of any specific law, then the judges go and pass the decision on the basis of justice, equity and good conscience. Okay. Now this justice, equity and good conscience is a concept of the English law. So we will go back to what are the rules of the English law and we can apply it. This will only be done if the present law is present matter, there is no law, etc. So I'll give you an example. For example, acid attacks is nowhere mentioned in the IPC. But what we are saying, acid attacks is not directly mentioned, because that time when the IPC was made, we never thought of these things. Cyber crime, we never thought. So when the new matter comes, then the judges will have to apply their mind, and on basis of what the principles were there by the English laws, which were called as the justice, equity and good conscience, it was actually introduced by English law, Impey's Regulation 1781. So we will pass as per that. In absence of any rule, the Indian courts can apply the justice, good equity and good conscience, which mean that the rules of the English law, insofar as applicable to the Indian society, can be applied. When the law is silent on any matter, they should be decided on basis of the justice, equity and good conscience by the judges. The Supreme Court has stated that it is now well established that in absence of any rule, we can apply the principles of justice, equity and good conscience unless it is repugnant, inconsistent to the Hindu law. Repugnant means what? Unless it is contrary, unless it is against the Hindu law, then unless it is not contradicting the Hindu law, then we can apply the principles of justice, equity and good conscience. Then you can do the headings for the English law. Okay, so all this not important from exam point of view. Okay, now coming to the legal theories. Now we come to the legal theories. We have already done it above, so I'll go a bit faster and just give you the keywords to remember from here. Till here it is clear. Okay. Now let's see the jurisprudence. Legal theory. Now jurisprudence, the subject itself, Latin word, the jurisprudence is derived from the Latin word jurisprudentia, which means knowledge of law. Juris means law and prudentia means knowledge. So we can say this, you can quote it in your exam. Jurisprudence means the study of law. Legal theory, again we have seen that there are different definitions and intellectuals which we will see. First, definition of jurisprudence given by Hart, H-L-A, Hart. Now I have given you a keyword, remember, primary and secondary rules. So remember the word primary and secondary rules for Hart. Okay, let's see. Professor H.L.A. Hart, okay, that is his name. Why are they calling H.L.A.? Because his name is Herbert Lionel Adolphus Hart. So it's better to call him H.L.A. Hart. He was a British legal philosopher, okay, and he was a professor at the Oxford University. His famous work is a concept of law, which is hailed as the most important work of legal philosophy written in the 20th century. So little bit of facts you can write about him before we get into the those primary and secondary rules which I told you is the main thing. So little bit concept more. The concept of law according to Hart is of legal positivism, okay, and legal morality. Legal positivism means that the views of the laws are rules made by laws and there is no inherent or necessary connection between law and morality. So a law can be immoral according to a certain people. So according to him, law and morality are two different things. So there is no connection, there is no necessary connection between law and morality. So which is a law in other countries, we might file it immoral. Now once you've written the introduction, then the most important part, the primary and the secondary rules. The primary and the secondary rules. So first, rules are of two kinds, primary rules and secondary rules. Now let's understand what is this Mr. Hart saying. Primary rules regulate the behavior of a man. The rules either grant rights or imposes a obligation on the members of the society. Examples of primary rules, that rules prohibiting murder, robbery, rash driving, etc. So this is the basic thing what they are prohibiting you from doing. Now what is secondary laws? Now those laws stipulate how and by whom the primary rules may be formed, recognized, modified and extinguished. So contract rules enables the parties to form the contracts, rules that allow the testator to create a will, etc. So primary rules with the state already makes. Secondary rules is where you can yourself modify what all contracts you want, what all obligations you want, etc. So secondary rules are those that stipulate, that state how and by whom the primary rules may be formed, recognized and modified. So Contract Act, when you make wills, you get a right to decide what all you want to do. So the Hart's basic idea is quite simple. Okay, Hart's basic idea is very simple, that the primary rules are the rules of conduct, that they tell you what you are legally obliged to do and you are refrained from. Okay, such as criminal laws, what you can and what you cannot do, whereas secondary rules are everything except primary rules. Clear? So I can say that the what you cannot do is given in your IPC, Indian Penal Code. What you cannot do, what are your rights, are given in your constitution. All the other laws are your secondary, like your Contract Act, will, which you can only decide what will be there only. Now we've done one thing. John Austin, he is positivistic. Positivistic means what? Command of the sovereign imposes a duty and a sanction. Kelsen, there is a grand norm, that is a constitution from which mother of all laws, from which all the other laws are made. Normative science, law states what should be done and what should not be done. Now let's see. John Austin, we have done this command theory of law. He has given three elements of law. One is there will be a command by a political superior. He will be sovereign. It's your duty to follow, and if you don't follow the duty, you will get a sanction. Okay. Then in the criticisms, you can say that nowadays in today's theory, there is kings and all that really gone. They cannot make any laws today in modern states today. Okay. Then we are talking of welfare. There are no commands. They give you certain welfare propositions where they give you rights, etc. Okay. And the Austin does not talk about judges. And since the presence of sovereign is a prerequisite of law, Austin did not recognize international law where there is no sovereign at all. So when we have international agreements, there is no sovereign at all, but still international agreements and conventions are law. Then Kelsen, just remember the word pure theory of law and a grand norm. Pure theory of law and a grand norm. So Kelsen is an Austrian philosopher known for his pure theory of law. He believed that law were impure as they drew upon from various other fields like religion, morality to explain legal concepts. Legal concepts are coming from here and there, so according to them, it's becoming impure. He believes so. One is that pure theory of law is one point. Normative science is one, which law will state what ought to be and what ought not to be. It tells you the rights, do's and don'ts. Okay. Then all norms derive their powers from the ultimate grand norm. So which is like your mother of all laws, the grand norm, which we call it as the constitution. So grand norm does not derive its validity from any other norm, but all the other laws derive its power from here. In India, we call it as the constitution. Then coming to your Rossio Pound. Now in Rossio Pound, write the keyword that is social engineering. Now everything with respect to society, social engineering, we see sociological jurisprudence. Rossio Pound is an American legal scholar of the 20th century. His biggest proponent was sociological jurisprudence. You can write everything about sociology. That it is the laws are made to as a social control to make an efficient society, to ensure that there is a proper balance of all the interests between individual and public interest. Then for a legal order to be successful in structuring an efficient society, a recognition of certain rights of individual, public and social is necessary. You have to understand that society, what are your rights? Public also have certain rights such as public peace, public nuisance should not be there, and as a society. Then you should define the limits of your individual rights, public rights, etc. and how do you secure those rights within the limits defined. This is given. Then comes William Salmond. The main keyword for him you have to remember is justice. So when we are done justice, the natural school of thought, you can write a lot about that as well. Okay. So he is, so little bit facts you need to write. He is a professor from New Zealand, also served as a judge of the Supreme Court. He made an important contribution in the field of jurisprudence. Salmon claimed that the purpose of law was deliverance of justice, and that was the main thing. Uh, Implementation of law, just like Bentham and Austin. So you can write about the natural school of law and about justice. So since law was defined by reference to administration of justice, human experience, it has to be understood that human experience has made it clear that some form of compulsion is required to maintain justice. So there is a kind of a social obligation that the law imposes upon you. So when you cannot drink and drive, etc. Okay. Then comes Jeremy Bentham. Just remember, whenever they ask about Bentham, Jeremy Bentham, there will be 8 different aspects. So just you have to write down the keywords and then you can mention those 8 parts. Okay. So Jeremy Bentham again. So these are little bit facts, but we need keywords to build an answer. Jeremy Bentham was the pioneer of analytical jurisprudence in Britain. He claimed that nature has placed a man under the command of 2 sovereigns, pain and pleasure. Now, he believed that every law may be considered in the light of 8 aspects. So he said every law you can understand that can be seen from 8 different angles. One is the source of the law, generally it is the will of the sovereign. The subjects on whom that law will be there, whether it will be persons or it will be property, things. Then the object, every act has a purpose, okay, which is there. Extent of the law, the aspect may be either directive or sanctional, so whether it is a procedural law or a substantive law. Force, every law has some element of obligation. How do you get remedy and the expression? So these 8 parts you need to little bit mug up is also there. So this 8 parts you can do, and I believe that's all that is there for this chapter. Now we'll just go quickly through the exam questions for this chapter, sources of law, and see whether we are able to answer it. Clear till here? So good to go. Okay. Yes. So basically all those things have been repeated. Those theories of law, you can study it when you're doing your first part only of the chapter, the definition and this. Now let's see the exam questions and how much answer that they've written. So first in 2000 December 18 they have asked, critically examine the statement by Austin, the command as a sovereign. So again command. So remember he was a positivistic theory. He said that is a theory of the sovereign. So this is one thing we have done this. So I'm just reading out the questions and see the answer also you don't have to write too much. It's a 5-mark answer. This much is the model answer. You can write in your own words also, but the key words have to be there. Then came about Rossio-Pound. Critically examine the Rossio-Pound theory of interest. So again, in the very start, if you all have taken a screenshot, I'd given you keywords. So this talks about social engineering. So again, everything about the society you will write, the scope, and 5 things. Then they had spoken about discuss the doctrine of stare decisis. Stare decisis means what? Do not unsettle things. Whatever is the past judgment, follow it. Only when it is necessary, you can then reverse the judgment. Then in December 2020, they had asked justice, equity, and good conscience is a main secondary source of Indian law. Explain it. So we had seen that also. Then in June 2021, they have asked natural law says that certain rights are inherent by virtue of human nature and can be understood universally through human reason. Explain. Now again, when I told you, whenever they tell you inherent rights, automatically they are asking about the natural school of law and same points that you have to write. This is just in the last attempt that they had asked this question. Okay. Then they had asked, very important, what are the essential conditions of a valid custom? They've asked what is the essential conditions of a valid custom, explain any 4. So I told you there were around 8 points. From those 8 points you can choose any 4. Okay. Then in December 2021 they have asked, explain the concept of Kelsey's pure theory of law. Now again, analytical school, you have to remember that it was normative science, so you have to just take the keywords and then attempt it. Then again, they've asked this question in the last attempt. All customs cannot be accepted as a law. All customs cannot be accepted as a law. There are certain conditions, tests that need to be fulfilled. So we had seen all those tests which I told you, which is important. Then came Austin theory, command theory of law, again covered, and that is it. Okay, this is with lesson number 1 we have completely covered, and you've seen the exam questions, so you can focus on that. We've covered that. All the other things you can take a quick overview. So this much is for the first chapter. Now we will take a 15-minute break and then we will come in and do the next chapter. Now which next chapter should I take? Should I go as per the constitution, or I will take the interpretation of statutes? I will go as per the interpretation of statutes. I will start in the next 15 minutes. Okay. And I will complete it in one go. So be with me till the very end, and I will also take in the exam questions for it. Second, in the supplement, there was no question or changes for your sources of law, but there is one for constitution. When we do that, we'll do it. They've also done for one interpretation of statutes, which is also there. We'll see when we do it. Clear? So this is for the Constitution of India. Clear? So we'll return back and we'll complete this and the Constitution of India chapter. Clear till here? So we'll take a short break and we will come back. You all have to come back, be with me till we finish the got it. So people are saying Constitution, so we will go as per, we'll do the Constitution of India, cover it completely along with the past exam question right after the break. Okay, so I think we can return back in, let's say, 30 minutes because it is Constitution of India. Take your break and come back. I will start the Constitution of India. Time. अभी कितना time? So 2 p.m. we'll return back. That is it. Thank you so much. This was one of a very nice response. I'll make sure that I come back and whatever is there in Constitution, if it is, I'll cover everything that possibly can come in your exams, including the past exam question. So take a break, come back at 2 and we'll finish it. And Parth is also saying arbitration, all of that I'll discuss, but next immediately I will be taking Constitution of India. Okay, take care guys. 2 p.m. we return. Guys, am I audible to you all? Checking what was in this June. Communal Dacoity. Okay. Any law which is inconstitutional. Excellent. Under Constitution, Parliament is empowered to make a law even great. Okay, so we'll be starting with the constitutional law now. Okay, yep. So, and we'll complete the entire constitutional law. And I just seen a few, messages. I think you all were telling me to go a bit faster. So I will go a bit faster now. Okay. So at the same time, you all can take note. And this time there is a amendment. There is a kind of a addition of one case also in the supplement sheet, which I will also discuss. Okay. So we will be starting with the constitutional law now. With the constitution. So I will go fast this time. I will complete everything including the past exam questions and the entire chapter, but a bit faster. So I'll increase my speed also. Okay. So good to go. Can we start? So we'll just start in 2 minutes. So we'll just start so you can get your books of your constitution, whatever you have study material with in front of you, you have to finish it with me. Okay, and we'll be doing with the past exam questions. Okay, so we'll start in 2 minutes. Okay, okay, I don't have to go faster. Not too fast, sir. Okay, fine. So I will go at the same speed. I will go at the same speed in a way that you understand and learn properly as well. Okay, so good to go. 2 minutes and we start. Okay, so we start with the Constitution of India. Now, just the basics, which is not expected to come in your exam. The Constitution of India came into force on 26 Jan 1950. The Constitution has around 395 articles divided into 22 chapters and 12 schedules. Before the constitution starts, there is something called as the preamble. A preamble gives you a insight into the constitution. The basic principles of the constitution is given. It says that it is a window to the minds of the makers of the constitution. So preamble serves as an introduction to the constitution. It contains the basic aims and objects of the constitutions, and it is an introductory statement. I believe all of us must be knowing the preamble of the constitution. This is very it cannot come in your exam, but still just quickly read it and finish it off once and for all. So the preamble of the constitution states that we, the people of India, have solemnly resolved, have decided to constitute, to make India into, so we the people of India have solemnly resolved to make India into a sovereign. A sovereign means nobody will be supreme to us. We ourselves are supreme. So there will not be any rulers to Indians now. Socialist. Socialist means we will work for the benefit of the welfare of the people. A secular, that is, all the religions are equal in the eyes of law. A democratic republic. A democratic republic means government of the people, by the people and for the people. So we will only elect from amongst ourselves to govern us. That is called as democracy. And to secure to all its citizens, to all our citizens, the constitution will give us justice of social, economic and political, liberty. Liberty means freedom, freedom of thought, expression, belief, faith and worship. Equality, equality in status, opportunity, and promote among them, among all of us, fraternity. Fraternity means brotherhood. In our Constituent Assembly on this 26th day, November 1949, do we hereby adopt, enact and give to ourselves this constitution. So this is the initial part, the preamble of the constitution. Now, do you want me to tell certain exam importance to you all? Do you all want me to give you certain exam importance? Yes or no? Yes or no? Do you all want certain exam importance, which is surely going to come in your exam? So, in law or any, whether it be your executive or you be in your LLB, whenever there is Constitution of India, there are three important articles which 100% one of them has to come. So article 14, 19 and 21. Out of these three articles, and you can add in one more thing which is called as the writs. 100% one will be an exam question. Till here it is clear. So this is exam importance. So we will be starting in that order. We will be doing article 14 since it's very important. It has come in the exam. Article 19 and article 21. Writs are also covered but towards the end. So let's see what is article 14. So quickly I'll write. I think you'll know it also, but that is your right to equality. This is your freedom, certain freedom of speech and expression, etc. And this is your right to life. There are questions asked from your, and every attempt almost there is a question from these articles and these questions. So let's start. So better to know it properly. Language is a little heavy, means the language if you read it is simple but you need to learn it. So let's start. Right to equality. This is what we commonly understand. ये हम लोग normally use करते हैं, right to equality, article 14. But in reality, the title is equality before law and equal protection of the law. So what is article 14 exactly? Equality before law and equal protection of the law. Article 14 of the Constitution states that Now when this is the title and when we go inside, it says that the state shall not deny to any person equality before law and equal protection of the law within the territory of India. So there are two important words, that the state, the government, shall not deny to any person two things: equality before law and equal protection of the law. When I say equality before law, means everybody is equal, nobody has special privileges. Absence of any special privilege. So it shouldn't happen that some people are getting privileges and some people are not getting any privileges. We are saying no matter whether you're rich, poor, what religion, everyone, nobody will get any extra privileges. Everyone is equal before the law. Till here it is clear. The second is equal protection of the law. Now what does protection mean? Protection means if my rights are infringed, if my rights are violated, I will also get equal remedy. It shouldn't happen that someone is getting bail faster, somebody on the same matter is getting more compensation. So protection bhi milega or special privileges are also not there. So equal remedy is what they talk about. Clear till here? So this is more that don't worry if your rights are violated, if your rights are infringed, violated, taken away by someone, we will give you remedy. Same like what we would have given others. Equality before law means what? Nobody will have any special advantage. Till here it is absolutely clear, and I want you not to understand. Everybody will say that they've understood. I am using the word so that you learn the language. ये लैंग्वेज तुम्हें लिखना है, वैसे ही लैंग्वेज में तुम्हें एग्जाम में लिखना है, राइट? Now, when I say absence of any special privilege, but the president, prime minister get better privileges, equal protection. We see that certain when foreign these ambassadors come, they get more protection. So it is not necessary in every case. So there is a next concept or line that comes, which talks about law for Article 14. Forbids class legislation but does not forbid classification. So now let's break down this line and understand. So first part was giving the definition, equality before law and equal protection of the law. Then talk about, however, some people get better protection. So then we start talking about classification, reasonable classification. So the heading is reasonable classification. So that's how you connect. सबको equal privileges but नहीं मिलता है. So sometimes we have SC ST get more rights, certain reserved class get more rights, certain people get more protection. So does that mean that the Article 14 has been violated? Answer is no. Whenever there is a reasonable classification, it will be allowed. Now what do you mean by the term reasonable classification? So reasonable classification states that those equal in the eyes of law will be treated equally. But if there is inequality, maybe someone is from a humble background, poor background, so it is important to give him some special privileges so that he comes at same level. So for example, a person sitting in the village and without tuitions giving an exam and scoring 70%, and you getting full access, full tuitions, everything, and you also getting 70%. Are both of your skills equal? Answer is no. He is more smarter than you. He is more hardworking than you. Because with being at the disadvantage, he is there getting the same mark. So if we take the same thing among equals, if we do equality among unequals, it is actually inequality. So equals are to be governed by the same law. As regards to unequals, the same law cannot be applied. If you will apply, it will lead to inequality. Okay. In such cases, reasonable classification is allowed. So why does the prime minister have more protection? Why does the president have more protection? Because they are more at risk. They are more at threat. So they get more protection than you. Same way SC ST, in order to uplift them, women also get certain privileges, benefits to uplift them in the society because they are little bit suppressed. Reasonable classification, clear? So you then switch to reasonable classification. Then say that law, Article 14 forbids. Forbids means what? It prohibits class legislation. Now, what is class legislation? Class legislation means making laws without lawful justification. So, class legislation means making different laws for different class without a lawful justification, being arbitrary, unjust, and discriminatory. So, class legislation which does not have a proper rationale. Just if I say that pretty people will get more rights and not pretty people will get less rights. So this is a class legislation where you don't have a proper lawful justification to make this division. So Article 14 prohibits class legislation but does not forbid classification. Classification means uh, making making differentiation or a classification where there is a rational, where there is a logic, where there is a legal justification for it. Okay, now let's see. To build this, they are saying that the test of classification. Now you can write this case law because they are now asking write along with case laws also. Especially when the answer is important, they are saying write with case laws. So, State of Bengal versus Anwar Ali Sarkar. In that it is said, how do you classify? So they are saying there has to be an intelligent differentia and there has to be an object it is trying to achieve. Means what? If I am giving some special privileges, special rights to Prime Minister or to women or to SC/ST, so whether it is allowed or no, so first we have to understand, we'll put it in the test of classification. Let's put it to the test as given by Anwar Ali Sarkar. Is it founded, is this distinction founded on a intelligent differentia? So you will say yes, normal people and prime minister, there is a very clear difference. Women are prone to attacks in the night, so it is important. SC/ST are at disadvantage, so there is an intelligent differentiation that we can see. And when we make the law, it is with a certain object to achieve, uplift the women, protect the SC/ST, etc. So thus in the Anwar Ali case, it is stated that classification must be reasonable and it must have an object to which it is trying to achieve. The same thing has also been stated in the Tendulkar case, Ram Kishan Dalmia versus Justice Tendulkar, where they have given these points, same points. Article 14 forbids class legislation but does not forbid classification. Permissible classification must satisfy two conditions. Anwar Ali case, there has to be an intelligent differentia and there has to be an object which it is trying to achieve. Now, mathematical accuracy is not needed. A reasonable classification is allowed. Now, if I say who you are giving benefit, which SC/ST what in that, now they are saying with accuracy we can't tell you accurately like with exact amounts. We are giving a reasonable, it is a benefit that we are trying to give. Exact mathematical accuracy in division cannot be found. Justice, equity, good conscience also has to be applied. Even a single individual may be treated by a class himself. For example, president. President is an individual. For him, we can make a classification. It is allowed because it is intelligent differentia is there and the object it is trying to achieve. Article 14 condemns discrimination not only on substantive grounds but also on procedural grounds. Now, what does this mean? Article 14 is equality. Give equality. Don't give inequality and discrimination. Don't do discrimination. Now, discrimination can be done in two things. substantive law and procedural law. So substantive law is where the rights are given. So I give you less rights. That is also not allowed. I say okay fine, rights are same, but the procedural law, CPC, CRPC, for you the procedure will take 20 years, for him it will take 2 years. So discrimination cannot be done, whether it be a substantive law or a procedural law. And always if there is some uh, confusion with respect to the validity of a law, whether it is valid or not valid, the assumption or the presumption will be in the favor of constitutionality, or we will feel कि अरे wrong ही होगा. If it is challenged, we should be that it must be correct. Mostly our mindset, our presumption will always be in the favor of constitutionality, and someone who is attacking, the burden is upon him to show that how there is a transgression of the constitutional principles. मतलब the person will who is challenging that ये law गलत है, the person who is challenging that this law is wrong, he has to prove why it is wrong. Courts will normally believe that it is all correct until proven wrong. So we will believe that the law is constitutional unless proven otherwise. Okay, so we've seen how classification has been done for Sikhs. Now when they wear a helmet, for them it is not necessarily compulsory to wear a helmet. Certain relaxation is given because Sikhs have to wear a pagdi, okay, a turban. Now even if you go to see a police officer, judges get some extra protection because their life is a greater risk. Same privileges are given to SC, ST, women, minority groups, women and children, etc. Clear? So we are done with Article 14. Okay, so that's it. All those points you can write and build up your answer. Now we are going to the next one, another important article, which is your article number 19. Right to. Okay. Now we are doing right to freedom. Now what all rights are provided? Let's see. Very simple. This is Article 19. 1 A B C D E F G. Clear till here? So we are doing Article 19, which talks about certain kinds of freedom. Now what kind of freedom do we have? Firstly, read and tell me, is Article 19 available to citizens or to everyone? Quickly, is Article 19 given rights only to citizens or to everyone? Please read and tell me. Can anyone tell me? Okay, very good. So it is available only to citizens. So these are certain rights which are available to citizens of India only. So first is freedom of speech and expression. Second is your right to assemble peacefully without arms. So you can peacefully settle. So just see, it is a sequence. Okay, I can speak, then thoda or rights. I can assemble, gather without arms ammunition. Once I gather, then I can form associations and unions. People gather and they make their own union. Then that union will move freely throughout India, territory of India. After moving freely, they can even settle in any part of the India. 19(1)(f), that is right to property, has been removed, and we have Article 19(1)(g), which is the right to profess any religion. So we are seeing three main articles first, then we'll go to Article 13 and all of that. We'll be doing all the articles, don't worry. Now, practice any profession or any business or any. These are all the natural rights which are there. But now you tell me, we'll be going into each one also, and exam questions have been framed from them, and all the exam questions we'll be discussing. But you tell me, are rights absolute or rights have certain kind of restrictions also? Are rights absolute or rights can be restricted? They can be limited as well. Very good. So rights are cannot be absolute. There are some reasonable restrictions. Means what? If you have been given certain freedom to speak, you cannot speak in a manner which will affect the integrity of India or with the security of India or friendly relations with foreign states or public order. You speak in a way, give a hate speech, that all you can't do. Which is vulgar, decent, indecent, all those you cannot do. Which in court also you cannot go and speak in a way that you amount to contempt of court. You cannot defame anybody. Defame means make a false statements of someone's reputation. That you cannot do. And incite makes certain statements to incite offenses, to encourage offenses. So these are all your restrictions. These all you cannot do. So you have all those rights, but these are subject to these common restrictions. Now we will see in each one. Okay, mostly these are the common points. Now I want you to tell me, what does Article 19(1)(a) talk about? Very, very important, and it comes in your exam as well. Okay, so once and for all we'll do it properly. We are going to see scope and limitation on the freedom on each of them. So we saw the reasonable restriction, but each one we will see what they're given. Right to freedom of speech and expression. So all citizens shall have a right to freedom of speech and expression. Now what does it mean? You can openly, without any fear of any oral, written or anything, you can express yourself, write, make articles, broadcast, everything. The right to speak also gives you a right not to speak. So sometimes if I ask you questions, you can choose not to speak as well. This right is available only to citizens and not to other nationalities. Now we'll see when this freedom of speech can be restricted. Can I make that we will bomb Pakistan? We will, we should just bomb Pakistan. We should cut China contacts. Now all those things you as a citizen or a person cannot do. It is the government who takes, all these calls on how to deal. So if you are making any speeches which is affecting the sovereignty, integrity of India, friendly religion, relations with other countries, etc., your speech can be restricted. Very, very simple. From childhood we are doing all this. Next, we are going to see certain landmark cases, okay, with respect to freedom of speech and expression. So first is the Maneka Gandhi versus Union of India. So it was a very important case. Article 21 was also hit. Article 19 has also been hit in Maneka Gandhi versus Union of India. Now what was laid down here? That he wanted to move abroad, he wanted to speak. So it was said that freedom of speech and expression has no geographical limitation. A citizen carries these rights wherever he goes. So you can go and speak wherever you want as well. Now these are just general points. I will tell you which one is important. Indian Express versus Union of India. It said that press plays a very significant role in democratic machinery. The news channels, they play a very important role to uphold the freedom of press is very, very important, and we should protect this freedom of expression because they will express in newspaper articles, etc. Next, Romesh Romesh Thapar versus State of Maharashtra. Freedom of speech and of the press laid at the foundation of all democratic organizations. So freedom of speech and press. So now all this is not important, but this is saying that the press, the news channel should also get complete freedom to speak without any political intervention and as much as is lawful. Then comes to Cricket Association of Bengal versus the Ministry of Broadcasting. It said that you don't even have a right not only just speak but also broadcast comes here through any print, electronic or audio visual. So you have a right to speak more extended word is you can communicate as well. Okay. Now this is one interesting case. Now you have to tell me whether it is allowed or not allowed. From your all the cases just for knowledge sake where you can quote it. Now you tell me in this case, Emmanuel versus State of Kerala, whether freedom of speech includes the right to remain silent. So there was the national anthem playing, and three students stood up but did not sing the national anthem. So can they be? So they were expelled from the school. They were removed from the school for refusal to this. However, they had stood up when the national anthem was playing. Now you tell me whether it is allowed or not. Whether that expulsion is valid or not valid. What do you all feel? So the validity of expulsion of the students was challenged before the Kerala, and upheld the expulsion on the ground that it was their fundamental duty to sing the national anthem. However, this was it was held by the Supreme Court that the students did not commit any offense. There is no law which their fundamental rights could be curtailed or article. So ultimately they were not wrong. They have stood up. They have an option to remain silent as well. This was decided by the Supreme Court of India. Okay. Then again, in this case, K. Abbas versus Union of India, the movies were being censored. Like let's say there are so many, we've seen censor board, they cut certain shots. So can I say I want to show this to the world, how you can cut this, and I go to the particular court saying that my movie certain clips have been cut. Can you do that? Yes or no? Will it fall under the reasonable restriction? Answer is no. They said that censorship of films, including pre-censorship, is justified. Okay, but the restriction must be reasonable. So in Abbas versus Union of India, censorship can be done by itself. It does not affect the rights of the person, because if the restriction is reasonable, it is allowed. Then in Union of India versus the Assassin for Democratic Association for Democratic Reforms, the freedom of speech and expression comprises not only right to express, publish and propagate the information, but also to receive the information. Very, very interesting. I can speak only when I know. To know, I need to get information. Today, only if you come to know that the government has done so and so crime, will you speak. So they are saying that speech and expression, for speech and expression, it is important to know. And to know, you have a right to get information. So from Article 19(1)(a), because in order to speak, you require information. So the Right to Information Act 2000 was passed. Next, if we see, so this was Article 19(1)(a). Rest all is very simple, okay, which is not really asked in the exam. You can quickly move ahead. So as we've seen, Article 19(1)(a) talks about assembling peacefully without arms, okay, but it should be non-violent and it should not breach public peace. So sometimes when you have certain kind of protest, that protest should be non-violent and it should not disturb the public law and order. Okay. However, the government can restrict it if they feel that the integrity of India is being affected or the public order is being affected. Same with all these points. Now coming to the G1, very, very important. Article 19(1)(g). Article 19(1)(g). It's a freedom to do business, to practice any profession or to do any business. So the Article 19(1)(g) guarantees to all the citizens that they have a right to practice any profession or carry on any trade or business thing, as they when the freedom is not controlled for Article 6 imposes a restriction on this freedom. Now, obviously, in all these articles, when you see article number 6, they give you the reasonable restriction, which we will read. Now, Article 6 is imposing certain reasonable restrictions. Can you, when you want to do any business or profession, you have absolute right, or these rights are limited? It is subject to reasonable restriction. So every single right has a reasonable restriction. Let's see, when can the government stop you from carrying on any business or any profession? First, if the government has prescribing certain professional and technical qualifications, you cannot sign a balance sheet till you're a chartered accountant or a company secretary. So how can you practice? Because the signature requires you to qualify certain exams. You cannot practice in High Court till you have completed your LLB. So this is a restriction that you cannot practice any business and profession unless you've got that qualification to do that. If you want to be a doctor, it is important that you have to pass your MBBS examination. Next, the carrying on by the state or by a corporation controlled by the state of any trade or business or this. Okay, so what are they saying? The reasonable restriction is the carrying on by any state of any business, trade or activity. For example, trains. The government has a state monopoly. Then you cannot claim that you can do any business. Printing of notes, defense. You cannot say that you will go ahead and defend the country because this is all coming under the state monopoly. So if the state itself is conducting a monopoly business, then you cannot claim your rights. Okay, they have given you instances of restriction. So in Nashivar versus State of Madhya Pradesh with respect to trade in liquor, alcohol, the government had put certain restrictions that you cannot do because it is affecting the public morality. If you go and see in Gujarat, it's a dry state. Alcohol is not legally allowed to be traded. So if the business owners go and file a case in court, then the Supreme Court held that the fundamental rights are not violated if we are prohibiting or putting some restriction on liquor business because it is in the interest of public interest and harmful and dangerous character of liquor. So if the government makes a law, then you can't challenge. Next, State of Madhya Pradesh versus McDowell. Similar this with respect to liquor. They imposed severe restriction, but it was held that it is allowed. You can put the restriction. Now another important is, I think it's asked in the past exam also, Hawker Association versus Bombay Municipal Corporation. Now tell me one thing, these hawkers जो रोड पे ठेले लगाते हैं and they do, is it allowed or not allowed? Allowed or not allowed? So the answer is, the government has said, see, the municipal corporation has a responsibility to maintain that the footpaths are clean, there is no public nuisance. So if the municipal corporation has taken certain actions, the Bombay hawkers cannot go to the court. So they had gone to the court against a certain cancellation. However, the government stated that it is well within reasonable restriction to stop the hawkers when it feels that public interest is involved. So public streets are by very nature and definition used for general public. No person has a fundamental right to carry on business and cause nuisance, annoyance and inconvenience to the public. So you cannot do, you have to listen to the municipal corporation. Then came another important case, which is of Chintamani Rao versus State of Madhya Pradesh. Very, very interesting case, and it is also past exam question. Now it was with the Madhya Pradesh government. Madhya Pradesh government, what it did, they prohibited the manufacture of BD in villages during the agricultural season. Now imagine if what will happen to those who are dealing in BD. So let's say BD is a kind of a cigarette. Okay. So BD was prohibited during rains, agricultural season. So then they become really sad that why you're doing this. So government said we want you to do agricultural activity during that time. Isliye we are not allowing you to do the business. You think such kind of restriction is valid to force them to work into and tell them you can't work anywhere else? Only availability is agricultural sector. Can you force someone? Yes or no? Yes or no? So it was held that this kind of restriction is not allowed. You cannot force a person to not enter into a profession only. No person residing in the village could engage himself in the manufacture of BD. The objective was to ensure adequate supply of labor to agricultural purposes. The court held that the prohibition was unreasonable and unfair. So this is not allowed. You cannot stop someone from doing anything. Constitutional provisions regarding state monopoly. So state can have monopoly. Normally you have all the right to do whichever business and profession you want. But in certain circumstances to serve the people, the state monopoly is allowed. States create a monopoly in its favor without being called upon to justify its action in the courts as being reasonable. Article 19(6), which gives you the reasonable restriction, makes it clear that the freedom of profession will not be understood to mean prevent the state from undertaking any activity. If a law is passed creating a state monopoly, the court should inquire as to the provisions of the law and see what is the real reason for making the state monopoly. We all know that railways is a state monopoly, it is allowed. Defense is a monopoly, it is allowed. So even transport generally was there, public transport was allowed. So state constitutional provisions, it's allowed. So we are done with Article 19 also. Now we are doing the next important article, which is Article 21. Article 21 talks about protection of life and personal liberty. Now this is important, super important. It is called in simple words right to life. Right to life. Courts have stated that the Article 91 is the heart of the Constitution. It is the heart of the Constitution because it is giving all those rights to you which makes life meaningful. मतलब क्या आप पढ़ते life. Can we take away the life of someone? Yes or no? Can we take away the life of someone? Yes or no? Can you put in the chat box? Can we take away the life of someone? Answer is no. However, don't you think we have hanged terrorists? They are hanged to death. We've taken away their life. So what are they saying? That you can do because a proper procedure of law was followed. So no person shall be deprived of his life. No person shall be killed or his life can be taken. Or his personal liberty. Personal liberty means freedom. Jail mein dal dete, if we put you in jail, your personal liberty is affected. So no person's life or personal liberty can be affected unless the procedure established by court is procedure established by law is followed. Okay, you have to follow a certain procedure established by law. It went into court, evidence was there, appeals was finished. Then we decided that hang till death or jailed for so many years. So you can take away their life and you can take away someone's liberty, but only after a proper procedure established by law. Okay, right to life includes all those rights which makes life meaningful. It is the most cherished life in the right in the world. Okay. Now, in Correct Singh versus State of UP, what happened is Kharak Singh was in jail. He was allowed to go home on parole, okay, on parole basis. He was allowed to go, but the police inspector was continuously following him. When this Kharak Singh went to meet his wife, also the police officer followed him. So Kharak Singh got very angry and he filed a case in court saying that my right to privacy is being affected. And court held that right to life includes right to privacy and a right to sleep as well. So the court held that visits, the police officer suddenly visiting in his house, is an invasion on the part of the police of the sanity of man's home, an intrusion into his personal security and his right to sleep. Therefore, violative of article of the personal liberty. So Kharak Singh was allowed to meet his wife, okay, and this kind of surveillance is not allowed. In Maneka Gandhi case, it was said that uh, right to life includes the right to go abroad as well. Okay, so her passport was impounded arbitrarily. So law said that it is vague and you cannot make a vague law and try to take away someone's passport. Then this said that you can go abroad as well. Right to life includes the right to travel as well. Now when we say the procedure established by law, so you can take away the right or something but only after the proper procedure established by law. What do you mean by the term procedure established by law? इसका क्या मतलब होता है procedure established by law? Can you even message? So the expression procedure established by law means a procedure, CRPC, CPC was followed. There must be a law justifying interference and the procedure must be fair, just and reasonable. It should not be arbitrary, fanciful and oppressive. Means if you're taking away someone's right to life, etc., but you can only do after proper procedure which is fair, reasonable and just. Now again they have given Article 14, Article 21, right to life includes right to go abroad, right to privacy, right to legal aid, right against custodial violence, rights to live with human dignity, right to live in a healthy environment, etc. This was Article 21. Just after 21, you have 21A, which talks about right to education. So the state shall provide free and compulsory education to all the children of ages 6 to 14 years in a manner as they may want by law determined. So 6 to 14 years free education is there in India. 6 to 14 years you get free education. This is given under right to education. Now in this case, in Fahima Shireen versus State of Kerala, it was held that the right to internet access is also a fundamental right, that you also need internet today in today's time. Then came to our fundamental duties. You can read it up. It's Article 15(1)(a). It says that you and me have certain duty. Now we were talking about rights. All this while we were talking about rights. We also have certain duties to follow. So duty to abide by the constitution, duty to cherish the noble ideas of our those who had gone through the freedom struggle, uphold and protect the sovereignty, unity and integrity of India, defend the country, promote harmony, preserve the rich heritage of our country, protect the environment, develop a scientific mind, temper, safeguard the public property, strive towards excellence in all spheres, and provide opportunity for education to one's child. So these are our fundamental duties. I told you all the rights, Article 14, 19, 21 and writs is from your short exam question will come. It has always come, it will always come in your exam also. Now let's understand what are writs and what are the different kinds of writs given. Clear till here? Okay. So let's see. Whenever your fundamental rights, which are given in your part 3 of the Constitution, they are violated. Whenever the fundamental rights are violated or infringed, that time you will can go to the High Court or to the Supreme Court. In Supreme Court, you will go under Article 32, and here you will go under Article 226. So whenever fundamental rights are violated, you will go to the High Court and Supreme Court. The application that you file will be called as a writ. So moment someone has filed a writ, I will immediately understand that some of his fundamental rights are violated. Till here it is clear. So whenever the fundamental rights are violated, it is called as a writ. Now writs are of different kinds. One is your 5 kinds: habeas corpus, mandamus, prohibition, certiorari and quo warranto. So these are the 5 kinds of writs that they have given. Any one of them they can ask you in your exam. So let's see what you mean by habeas corpus. First, habeas corpus means to bring the body, to have the body. So whenever it only comes in case of illegal detention. So if any person has been illegally detained, किसी को तुमने पुलिस ने बेफिजूल wrongly confined कर दिया, if anybody has been confined wrongly, then that person can write to the High Court or the Supreme Court, or his lawyers can write to the High Court and Supreme Court that he has been illegally detained. So the court will have the body, will call that person to check the legality of his detention. If they find that he has been wrongly detained, the courts will secure the release of the person, will ask for release of the person. However, if the courts find that this person is there, he is actually wrong, then he will be put back into the jail or detention. So this main objective of the habeas corpus is to secure the release of an innocent person who has been wrongly detained. So it means to bring the person who has been detained to see the legality of his detention. So अगर किसी को wrongly detain कर दिया है, पकड़ के रख दिया है, तो वो फटाफट केस फाइल करेगा habeas corpus कि मुझे रिलीज कर दो, that release me. The object of the writ is not to punish. The object of the writ is not to punish someone who has illegally detained another. That's not the object, but the object is to secure the release of a person who has been illegally detained. Then coming to mandamus. Always remember man. Just for understanding, man orders. So commands. Mandamus means command. So it is an order by higher court to a public authority to do its public duty properly. Okay? For example, we are saying the High Court is commanding the BMC, Municipal Corporation, the roads are so dirty. What are you doing? Go and do your duty properly. So this command can only be given by a higher court to a lower authority who has public duty to perform. You cannot issue it to a private company. You cannot tell a private employee do your work. So court can only tell that it's your duty to keep the area clean, to make the roads, etc. So that is there. Or the police officer is not filing FIR or not doing anything. You call that authority. What is your problem? Do it. So then the order comes. Okay. So writ of mandamus is a command issued to a person who is having a public duty to perform the duty correctly. Mandamus can be issued only against any public authority. Next. Now when we read prohibition and certiorari. Okay. Now what is prohibition and certiorari? Now both of them come in the same case, similar case. Okay, so let's say if there is a wrong matter, or the higher court has realized that the lower court has taken up a wrong matter, or they have found that you are exceeding your powers. You are exceeding, the lower court is exceeding their jurisdiction. Jurisdiction means power. Okay. Then the higher court will tell the lower court that, listen, if the decision is passed, so if the decision not passed, so the decision of the case is not passed, and here it is passed. So if the decision is not passed, then we will prohibit them, then issue a prohibition from continuing the case. So then we will say we'll prevent them. Prohibition means what? Prevent them from passing a erroneous judgment because you don't have powers. Sometimes the lower court might take up a matter which is not within their jurisdiction, and the matter must be taken up. But if the decision is already passed, we realize later on that the lower court already passed the judgment, then in that case we will have to call the records for that case and then quash it. So to quash the order or judgment of lower court. Clear? So when they quash it, it is called as certiorari. So both of them is a higher court rectifying the mistake of a lower court. But if decision is passed, certiorari will be filed. But if decision is not passed, then they will be prohibited. So prohibited is preventing the lower court from aspersing the jurisdiction which is not legally vested in it. So you're preventing the later from exceeding a jurisdiction which is not legally vested in it. Certiorari means what? You squash, set aside a decision which is beyond the jurisdiction. If we have found that you've exceeded your jurisdiction, contravened any rules of natural justice, or you've done a mistake apparent on face of record. Then comes the last one, which is your quo warranto. Quo warranto means what? By what authority? So if I was applying for a government job, now this applies only in case of a public office. It can apply only in case of a public office, not in a private company. Government post is there. Now in the government post, due to some connection or some other person got the job. I would have got because I have more qualifications and I was the next number. So I can file a case in court that, see, listen, I'm filing quo warranto. Please ask that person by what authority is he appointed. So then the court will call that person and ask to check the record by what authority is he holding the office. It is issued when an office of public nature is there, which has been created by the constitution, statute, etc. And the person who is crying or complaining really is ascertaining his claim to the office. So the person is saying that if he wasn't appointed wrongly, I would have got the job. So then the High Court will say, okay, fine. We'll ask that person by what authority and qualifications and merits is he holding that job. Now these are all the 5 writs. Then we come to the structure of the constitution. Now structure of our constitution is another separate question which they can ask. Now these are the main characteristics of federal constitution. So whether our constitution, can you all message and tell whether our constitution is federal structure or it is a unitary structure? Can you all message and tell? Correct. So it is neither completely federal, neither completely unitary. It is instead a quasi-federal. Quasi-federal means partly federal and partly unitary. So our Indian constitution is quasi-federal because it has all, these are all the main characteristics of federal. We also have a dual government. We also have distribution of powers. We also have supremacy of our constitution. We also, our judiciary is also independent, and we also have a written and rigid procedure for amending the constitution. So that is all ticked. So we are federal characteristics, but we also have unitary characteristics. In unitary, what happens? All the powers get united in one place. So we have single citizenship. So this feature is also there. Of unitary is also there. Precedence rule, at the time of precedence rule, all the powers vest with the president. So that is also there. Residuary power, any matter which is not specified in the constitution or anywhere, all that power will come with the central government. Same thing is there for us also. Judiciary, then they're saying that the Supreme Court is the most topmost court. So all the features of federal we saw, all those features, even the features of unitary are there. So we can nicely conclude that our constitution is neither purely federal nor purely unitary. It is a combination of both. Till here it is clear. Structure of our constitution. Now we'll be doing this question: power of parliament to make laws on state list. Now this is the exam question. Exam question. Okay. So let's see. Very good. So let's see power of the parliament to make laws on the state list. First, understand one thing, that Article 246 read with Schedule 7. Now you have to tell me whether you read this. Divides the powers of the court. So it divides the powers of the court, powers of the government. That this power is available to the union one. There are three lists, right? Union list, then the next one is a state list, and the third one is a concurrent list. Have you heard of that? Yeah, three lists. All the matters, so in our constitution there are three lists. Whatever matters are stated in the union list, only the central government can make laws. Whatever is stated in the state list, only the state government can make laws. And whatever is given in the concurrent list, both can make the laws. Yes or no? Till here? Yes or no? Both the governments can make the law. Now, there are cases where normally encroachment is not allowed. Means the central government cannot make a law which is there in the state, and the state government cannot make a law which is there on the union list. Till here it is clear? Yes or no? I want you to message whether this concept is clear, that whatever is mentioned in the central list, only the central government can make, and whatever is there in the state list, only the state government can make. Till this is clear? We have done this in civics in our school. There are cases, at certain times the central government can make laws and encroach upon the state list and make laws. Now what are those cases? They have asked in the exam. Very good. So let's see. So pay attention. So power of parliament, when they say parliament, means what? Central government, to make a law on the matters which are there in state list. Tell me one thing, state government will be happy or sad? State government will be happy or sad? Quickly, I want you to message whether the state government will like if the central government is making laws on something which is there in their matter. So exactly, so the state government will be sad. So we will see in which all cases will that central government get so much powers. First, in national interest. First point. Firstly, in national interest, a parliament can make, so I'll tell you very simple, a parliament can make a law a parliament can make a law with respect to a matter enumerated in the state list if the Rajya Sabha declares by a resolution supported by two-thirds of its members and voting is necessary and expedient in national interest that parliament should a law be made on matters enumerated in state list. Simple words I'll explain. Whenever in the Rajya Sabha two-thirds of votes are passed, two-thirds votes are given, that central government should make a law on matters stated in the state government. Then they will make. Now everyone is representative of the state governments are there in Rajya Sabha. They themselves are only saying, make it so it will be made. For example, from many years we are trying to make a law on Lokpal bill. If today members of the Rajya Sabha only pass a law that we require on national level law to be made, so even if it is in the state list, everyone is only telling the central government make us national laws. So that can be done. So in national interest, when Rajya Sabha members are telling and make a law, then it will be made. That's the first part. Second, and it is given in your article number 249. 249. I want you to remember with the article number this. Next is proclamation of emergency. Now article 250. So whenever there is a national emergency, external aggression, war, or basically a threat to the security of India, so immediately the proclamation can be done and the president will get a president rule will be declared and all the powers of all the states will vest in one man, that is the president. So during emergency the parliament shall have a power to make a law for whole or any part of the territory of India which is matter which is there in the state list. Article 352 states that if the president is satisfied that a grave emergency exists whereby the security of India is threatened, whereby war, by external aggression or armed rebellion, then the president can proclaim a declaration to that effect and take all the powers. Now here it is important to note that actual war is not necessary. Even a perception or a feeling or a presumption that war will be done, immediately president can take up all the rights. Breakdown of constitutional machinery, this is the third point. So if a state cannot function as per the constitution, there is a lot of violence in that states, riots, etc. Immediately the president will take the control. In case of a governor, in case of state, reports to the president. So the governor will write to the president that in this state there is cannot be run. He is satisfied that the state cannot function and there is a breakdown of constitutional machinery, then the president's rule will be declared. This is given in your article 356 and 357. Then comes your on request of two or more states, article 252. So when two or more states only happily go to the government, central government, and say make a law for both of us. So parliament will say, okay, you have only come, we'll make a law, big deal. So parliament can legislate for two or more states with their only consent. Price Competition Act is an example of that case. Then legislation for enforcing international agreement. Article 253. Now imagine if India Prime Minister Modi has gone and entered into an international agreement. Can Goa state say I will not follow? No. So whenever there is an international agreement that India has entered, automatically that law becomes applicable on all of India, including all the states, even if that matter was there in the state list. Till here it is clear. So we had seen there are 5 cases. Now when Rajya Sabha members are saying national interest, there is emergency, breakdown of constitutional machinery, two or more states are themselves saying, or a international agreement is there. Clear? Now Now next we are going to see the definition of state. This has also come in the exam. Now what do you mean by state and how do you determine whether a particular agency is to be considered as an instrument of state, that it is under the state government? It's very simple, but first let's understand state. Article 19. Many times you must have seen ABC versus the state of Maharashtra. So when can you make the state government liable? And state government, if they lose the case, the state government will have to make the payment. Now when can we make that case possible? Okay. So let's see. The state includes, when we say the state, it means the government, state government, the parliament, the government and the legislature of each state, and all the local authorities which are coming under the territory of the or under the control of the government. So whenever we file a case against the Union of India, so we are saying that the government, parliament, they are legislature of each state, all the local authorities which are under the control of government are to be termed as a term as state. Very very simple. So if any agency has been set up by the state, it will be considered as an agency of the state and will come under the definition of Article 12. Till here it is clear. In this case, so anything which comes under the control of the government has set it up, will come as a Article 12. In Z Telefilms versus Union of India, the Supreme Court held that the board of control for BCCI was not the state for purpose of Article 12. Whether BCCI, we all watch cricket, is the BCCI considered to be an instrument of state? If it is a state, then the state has control. So it was held that it is an independent body. The state does not fund it, state does not control it. It governs it is different, but it doesn't under direct control. So it is not. So it was shown to be financially functioning or independently. It was not shown anywhere that the BCCI was under direct control of the government. So the BCCI is not coming under the definition of Article 12. Now this was there, and this has been a past exam question also. Ajay Hasya versus Khalid Mubib. The Supreme Court has given certain tests to determine whether an entity is an instrumentality or the agency of the state. Whether something is an agency of state or no, they have given. How will you come to know? How can I come to know whether this state controls this agency? Very simple. If the entire share capital of the corporation is held by the government, life insurance corporation, so it becomes a instrument of the state. Next, where the financial assistance is given, money is funded by the state government only, then we will say, and the entire expenditure of the corporation is handled by the state. So again we are saying you're connected. These are all the tests, and very simple tests. Share capital, expenditure is held by the state. Whether the state has a monopoly status over it. So the state has monopoly status. If there is a deep and pervasive state control, simple word they can have used. If there is a lot of control by the state on them, we will say that is an instrument of the state. Because anything wrong done by that agency, the state will be held liable. Next is functions of the corporation are of public importance and closely connected with the government. So what, let's say the post office, very much connected with the government function, so it will be considered as the instrument of state. If a department of the government is transferred to a corporation, it was a government department, now a separate corporation is made, so then that corporation will also be treated as a state. So they've given you 6 tests to determine whether a particular thing is a state or not. Okay, so this was there in the past exam questions. Now we're going to see what do you mean by directive principles of state policy. Just give me 2 minutes. We'll just take a water break and come back. So we just take a 5 minute break, okay? 2 minute break. Hi. So am I audible to you all? Am I audible? Just waiting for your. Just I need you to message me. Am I audible? We quickly start. Okay, great. So let's begin. So the directive principles of state policy. Let's understand what it is. And this many people's concept is never clear. Okay, so once and for all understand. Fundamental rights, your fundamental rights are given in your constitution under part 3 of the constitution and part 4. What is given in your part 3 of the constitution are actually called as your fundamental rights, and these are enforceable by law. Enforceable by law, that means it is guaranteed. Whereas your part 4 of your fundamental rights, these are also your birthrights, but it is very high end principle, the most best thing that can happen, because so this is the basic rights given, your basic rights given, which the state has to give you, and if you don't get, you can go in court and enforce it and get it in your favor. Whereas part 4 gives you the most ideal principles what India should be. So this gives you the best and most ideal principles. Okay, they are called as your directive principles of state policy. This is not enforceable by law. Not enforceable by law. Here what they say that the, the state should direct its policy to achieve these goals. It is a duty of the state to direct its policy to achieve the goals given in part 4. You cannot force the state to do that. The state will try, will endeavor, will put in best efforts basis to achieve this most ideal principle. So what is given here? Let's see. For example, some of the example: free education and compulsory education to all up to 14 years. So the state tried and then they said that now we will give up till 14 years to all. They've also said that to set up, the state shall make efforts and make policies to make village panchayat, secure social order, ensure that there is proper human condition, people get a good standard of life. They they promote peace, security, harmony all over between nations, etc. So these are all most ideal principles. Have something called as a uniform civil code, which is a hot debate today. Uniform civil code, that everybody, as we have a uniform criminal code, doesn't matter whether any person of any religion has done a crime, the punishment will be the same. But if you see, we don't have uniform civil code. Civil code means with respect to marriage, with respect to divorce, with respect to adoption, with respect to inheritance, everybody is governed by this personal laws. तो वो तो यूनिफॉर्म नहीं है, it's not the same. But in a directive principle, it is stated that at one point of time we should get all the people to a same civil practice as well. Now coming to the next one is your article number 20. This is your past exam question. Okay, so this is again your exam question which has come. Article number 20. Language is little tough, but once you understand it, it's very simple. So let's see what does Article 20 talk about. Before we understand Article 20, understand what all we'll be doing. We'll be Article 21, sub regulation 1, Article 22 and Article 23. So 3 we'll be doing. Okay. So we have Article 21, 2 and 3. Okay. So this one talks about protection. So Article 20 is all about protection. Protection from ex post facto laws. So this is from ex post facto laws. Okay, so you can so Article 20, 1, 2, 3. This is protection from ex post facto laws. This is about double jeopardy. Double jeopardy is called as self-incrimination. And this is 3 is about double jeopardy, and the third one is self-incrimination. Self-incrimination. Let's understand what is this. Now, in your exam, which I asked first, let me tell you that. So, in your exam, they have asked one, the Article 20, sub Article 1. Now, what is post facto laws? Let's say an act when you did, it was not punishable. It was not punishable when you did, but later, let's say you did the crime you did an act in 2022. You did the act, it got over. In 2023, the same act became punishable offence. Can you be held liable now? Yes or no? Quickly. I want to explain you something very, very important. No one is a criminal in retrospective. Very good. So just tell me this part. Tell me this part. If you did an act which was not punishable in 2022, okay, can you be held, and that act became punishable in 2023, can you be held liable retrospectively backwards? So obviously you will say no, I will not be held liable, because when you did that act, it was not an offense. So you will not be held liable. So you are protected. Another example, if you did an act which was, and when you did that act, you in 2022 you did an act, it was punishable with maximum 2 years. Now matter is going on and on. In 2023, this same thing became 7 years imprisonment. Tell me one thing, can you be held liable with 7 years imprisonment? Yes or no? Can you be held liable with 7 years imprisonment? Very good. Answer is no. So why? Because when you did an act, it was punishable with 2 years only. So even if the trial goes on, you can be held liable for 2 years only. Even if subsequently the punishment has been increased. But you will say that when I did the act, that time what is the law, that is only going to be applicable on me. Is this clear? So I am protected with any future increase in punishment also. So let's read it and tell me whether you've understood it or no. Okay, I'll read it because this is exactly what had come in the exam as well. Okay. Protection against ex post facto law. No person shall be convicted of an offence except for violation of a law. So no person shall be convicted of an offence except if it was a violation at the time of commission of the act. This is the first part. Now the second part. Nor shall he be subjected to a greater punishment. Nor shall be subjected to a greater punishment which might have been inflicted under the law and force at the time of commission of the offence. So I cannot be held liable for an act which was not punishable at the time of doing it. That's one part. Second part says I cannot be held liable for a punishment greater than what was there when I did the act. So this is about protection against ex post facto law. So here they are giving you a situation, an example also. In last attempt only they had asked. Very, very simple. Then other protection against double jeopardy. No person shall be vexed or prosecuted for the same offence. This in your civil procedure code there is a thing called as res judicata. Once I am punished, now for the same thing you cannot put me in trial and punish me again. For that only you act again. So obviously you cannot be punished more than once for that act. Protection against self-incrimination. Now self-incrimination means you cannot be held to be a witness against yourself. A person cannot be held to be a witness against himself. Now someone will say, what is the meaning of this? Witness against himself means today in police custody, the police might beat up so badly that accused that he will only say, हाँ मैंने ही देखा कि मैंने ही किया है. I have done the crime, I admit it. He is giving an admission or confession before the police officer. So he is giving a self-incriminating statement, self-damaging statement. So law says you cannot force him to give a statement which is against his own self. So sometimes you have a right to be silent. In movies also you see they always say that you should be quiet. That is much better. So no person shall be compelled to be a witness against himself. Clear? So that is what they've given. However, a statement before the magistrate, if this is there, accused in front of police officer, if he is admitted and given a self-incriminating statement, self-damaging statement, it is not valid. But if the same statement is given before the magistrate, it is valid. Why? Magistrate is not going to come and hit you. There is no fear of violence from the magistrate. So if you give before that, it is allowed. This is given in your CRPC, admission and confession part. Clear? Article 20 clear? Article 21 we did right to life. Now we are seeing your Article 22. Not very important, so I'll go a bit faster on this. Article 22 says protection against arrest. Moment you are arrested under ordinary law means normally you will have to be informed why you are arrested. You have a right to be allowed to legal practitioner. You will be given someone who can defend you. And third, within 24 hours you will be produced before the magistrate to answer. So you cannot just arrest someone and keep him in jail only without producing him in court. So within 24 hours you will be taken. Now when it comes to preventive detention, you have not done an act, but we have got some information, we feel that you are a spy, we have something. So in prevention only we have arrested you because we had got certain information and we feel that you are going to do the crime. So we will not wait for you to do the crime. We will arrest you and start taking information from you. So means detention on a person without a trial. अब इसमें in this, think from the detainee point of view, think from the accused point of view. He will just say, I didn't do only anything and you arrested me. So now law will say that, okay fine, this is preventive detention. He will also get the same rights. But he cannot be detained for more than 3 months. A committee will have to be appointed if you want to extend it beyond that time period. Okay, the authority who is ordering that preventive detention should inform him the grounds and give him an opportunity to make representation and objection and through a legal counsel as well. Article 22 also done. Now we're talking about delegated legislation. Okay, This is the next topic called as delegated legislation. Now, what does delegated legislation mean? First, there is a legislation, there is a law. Who the law has been passed by a delegated authority, has been passed by an authority to whom the powers have been delegated. They are called as delegated legislation. Let's understand. The CBIC, the Central Board of Indirect Taxes and Customs, are actually responsible to make the laws and govern GST. However, the powers, rule making powers, have been delegated to the GST Council. Right? So this is the main authority, and this is the delegated authority to whom the powers have been delegated. Whenever the delegated authority makes the law, so whenever they use this power, this delegated authority makes a law, this law will be called as delegated legislation. What happens today? Parliament makes the main law, they make the main act, but they don't have time for day to day going and checking all that. So then they make a delegated authority and they say, now you only handle from your own. So there is, let's say for example, there is Ministry of Corporate Affairs. They are the main persons. They can delegate the powers to the ROC, Register of Companies, to make certain laws. Whenever the ROC makes a law, after getting this power, this will be called as delegated legislation. Now, why is the main authority themselves not doing? Can you tell me? The main authority should do it, na? Because obviously there is the main authority, there is a lot of pressure of work. Second, the subjects can be very technical. So you have a GST council who are dedicated for that authority. Technicality of subjects. Then when there is emergency situation, so then that time the main authority might not be able to come. The delegated authority will use their powers. And the delegated authority, being a specialized body, will be easier to change the laws and modify as per the day-to-day event. So this is the reason for delegating the powers. Next, classification kinds of subordinate or delegated legislation. There are 5 kinds of delegated legislation, 5 different kinds of delegated legislation. Let's see. Now this is not important, they've never asked, but let's see. Executive legislation. This here we are giving that you execute the law, you implement the law, you manage the law. So SEBI. So the central government is the main authority. They give the power for share market. They will say SEBI will handle. For financial sector, RBI will handle. So this is the executive legislation where we tell SEBI to make a law, RBI to make the laws, internal rules, bylaws, circulars, etc. Then comes judicial legislation. Judicial legislation is when the judiciary, courts might give it to a subordinate court. You make the laws, you make the bylaws. So they can also make their own procedure, Court Fees Act, with respect to what is contempt of court. All that the higher court is telling the lower court, you only make. So we are delegating. So that's a judicial legislation. When the municipal authorities delegate the power to certain to make their own powers, that's called as municipal bylaws. So municipal authorities are entrusted with the limited and subordinate powers of making special laws for any part, such as bylaws. This is called as municipal legislation. BMC circulars also come. The municipal circulars, that is there. Autonomous legislation. Autonomous bodies such as universities also get powers to make their own legislation and internal. So they make with respect to attire, what is the dress code, what is. So autonomous authorities are there. Universities, they are given the powers that internal attendance, mannerism, you only handle. Colonial legislation. So colonial legislation is outcome of colonies. So today when you go to see, not all colonies are free and supreme. Sometimes there is a superior body, and the superior body has given that colony to make a law. That is called as colonial legislation. So I'll explain. The Britain has many colonies, but they are all subject to the Queen. Whatever the Queen of Britain says, they are ultimately bound to listen. Colonies make their law, but they are not supreme. So those colonies, like how Britain has, they are all called as colonial legislation. Now all this is not important. Now coming to article number 13. This is also a past exam question and very important. Okay. So you all are with me. We are doing article number 13. Okay. So let's see. Yep. So what do you mean by article number 13 and what are the provisions with respect to it? Now let's say article 13 also has two sub articles, article 1 and article 13.1 and 13.2. This talks about pre-constitutional laws and this talks about post-constitutional laws. Post-constitutional laws. Now let's see, very simple. Article 13 talks about pre-constitutional and post-constitutional law. Now tell me, if at this point the constitution was passed, constitution was adopted on this day, do you think there were laws before the constitution? Yes or no? There were laws before the constitution, yes or no? Answer is yes. They are all called as existing laws. They were before existing when the constitution was passed. And there are future laws. I'm calling it as future laws. Future laws, that is after the constitution has been passed. So 13.1 is here and 13.2 is here. The easy one first I'll finish, which is your post-constitutional law. Can today we make any law which is against the constitution? Can future laws be made which is against the constitution? Yes or no? So no law shall be passed which is against constitution. Which is against constitution. Till here it is clear? Yes or no? Till here it is clear? No law can be passed which is against the constitution. Now, pre-constitutional laws. What are pre-constitutional laws? Now, pre-constitutional laws means laws which were there in existence before the constitution. So they will be invalid to the extent they are inconsistent with the constitution. They are inconsistent with constitution. Fine. So let's see. Clear? So only how much ever is invalid, that will be removed. If you can after removing the balance part, if it cannot sustain because the main part was only removed, then the full law will be repealed. That is one of the theory. Let's see. So first let's come to article 13.1 and 13.2. 13.1 says that laws relating to existing laws which were in force before the constitution came into law is called as pre-constitutional laws. It says that pre-constitutional laws are void to the extent they are inconsistent with the fundamental right. So how much ever portion is invalid to the extent means what? Means how much ever is invalid and conflicting with the constitution will prevail. Now when I come to future laws, that is very simple. Article 13.2. After the constitution came into force, the state shall not make any law which takes away the rights conferred by part 3 and which is against the constitution. If they do, that law will be void. Now from Article 13(1), pre-constitutional laws, two doctrines have come, and both the doctrines they've asked in the exam: doctrine of eclipse and doctrine of severability. Till here it is clear. So doctrine of eclipse and doctrine of severability. Now let's see, let's start. So this is all related to 13(1), pre-constitutional law related. पोस्ट कॉन्स्टिट्यूशन तो सिंपल है, उसके अगेंस्ट बना ही नहीं सकते, बट जो बन चुके हैं उनका क्या इज गिवन हियर. व्हाट हैव ऑलरेडी बीन मेड बिफोर द कॉन्स्टिट्यूशन, व्हाट अबाउट दैट इज गिवन हियर. So the first one, doctrine of severability. Severability simply means to separate or to cut. So if a pre-constitutional law has certain valid portion and has certain invalid portion. According to doctrine of severability, they are saying that the whatever is invalid, cut it, finish it off, that part becomes invalid. To the extent of inconsistency, that much will be removed. So Article 13 says to separate the valid portion from the invalid portion, separate it, and if the valid portion can continue, means as a separate law, it will continue. However, if I tell you that 99% of the act is invalid and only 1% is valid, then they will say this entire act will be removed. This entire act will be repealed because the valid portion cannot independently operate. So I'll read it out. When a particular part or a section is found to be inconsistent, whether the whole part should be removed or only a part, so then the Supreme Court says that only remove that part only which is inconsistent. If separation is not possible, we are not possible to separate only, then the entire act will get invalid. This is the doctrine of cutting. Cut kar do invalid portion. If invalid portion can be cut, cut it. But if it cannot be cut, the entire act will be invalid. Till here it is clear. It is not the entire law which is to be void, but the law becomes invalid only to the extent which is inconsistent with the fundamental rights. So only that part of the law which is declared as invalid or inconsistent, the rest of the law will be valid. However, on this point a clarification has been made. If the invalid part shall be severed and declared invalid, if if it is severable or separable. If the valid part is capable of being effect, then only it will survive, otherwise the court will declare the entire law to be invalid. Very, very simple. Now let's go to doctrine of eclipse. Till here you all have understood? Yes or no, doctrine of this? Now till here you all have done, so can we move ahead to the doctrine of eclipse? Clear till here? Great. So doctrine of eclipse, let's understand. This is also connected with Article 13(1), which it is saying that if an act was there, now pay attention, okay? This concept, it is very easy to understand but very difficult to word it, write it. So pay attention to the words also. First I will explain with certain very weird hand movements. Then I will take you to the proper legal language of it. First, if a law is there, it became invalid because of the constitution. The fundamental rights came and make this invalid. So this was a pre-constitutional law. It got eclipsed by a fundamental right. So fundamental right will prevail or this law will prevail? First tell me. Obviously the fundamental right. So if a prior law is there which is conflicting with the constitution will prevail. So can I say this is eclipsed? This old law is eclipsed with the constitutional restriction. So now question comes that this law, does it become dead altogether and invalid forever, or it only becomes inactive and dormant if ever there is a constitutional amendment and the restriction is removed, the eclipse is removed, this law will automatically be valid. Clear till here? Have you understood with the weird hand movements that if a particular pre-constitutional law is conflicting with the fundamental rights will prevail, and this law, old law, will become dormant, inactive, but not dead altogether. When I say not dead altogether means what? Whenever the restriction of the fundamental right is removed, when the fundamental right is removed, it will be active back again. Okay, perfect. So now let me just explain through the language also. Doctrine of eclipse. Article 13 is that though an existing law inconsistent with the fundamental rights becomes inoperative from the date of commencement of the constitution. So existing law became inoperative. Yet it is not dead altogether. A law made before the commencement of the law remain eclipsed, dormant or inactive till the shadow of the fundamental rights are there. Till the fundamental rights or till the constitution restriction is there. But the eclipse of the dormant part will become active again if the prohibition brought by the fundamental rights is removed through an amendment of the constitution. This is called as the doctrine of eclipse. Language clear? Now let's take it with the help of an example. So this was in Bikaji Narayan Shak Rus versus State of MP. Very interesting case. Very interesting case, which stated that, first let's understand, okay, there was the motor vehicles, so they had a monopoly over state. The government had monopoly on uh, public transport. Fundamental rights, Article 19(1)(g) said that everybody can do. A person has a right to do any kind of business they want in India. So obviously this had state monopoly. So state monopoly, and now fundamental right is saying everyone can do. So which will prevail? Fundamental right will prevail and this will become dormant. Later the government realized that we should remove this restriction for this thing, and we should once the restriction was removed that for this matter state monopoly can be done. For public transport state monopoly can be done. So moment the restriction was removed, this act became automatically valid. So in this thing, in Motor Vehicles Amendment Act, empowering the government to regulate, control entire motor transport business was challenged. The act was perfectly valid, but due to the commencement of the constitution, it contravened Article 19(1)(g) because they said monopoly no everybody can do. So to remove the inaffinity, to remove this issue, contravention, this hurdle, the Amendment Act was passed which permitted creation by law of the state monopoly. So that was removed. In case of that, the pre-constitutional law, doctrine of eclipse will apply. The act would now become applicable all over again. Then comes doctrine of waiver. Can you waive up? Waiver means giving up. You cannot waive off your fundamental rights. This is what it was decided. Then came ordinance making power. Now first we need to understand what do you mean by the term ordinance. Ordinance means a temporary law. Temporarily law. Now can you tell me who is the head of the country, head of India, who's the head of the country? Can anyone tell me who's the head of the state? So head of the government is your president and of the state is your governor. Okay. So president is of India. So president also has this temporary law making power, and even the governor will have for the state, and this will have for all over India. Now whenever the parliament is not in session, obviously to make the law you will have to have a session, but certain powers have been given, emergency law making powers have been given to the president and governor, that whenever they feel that the parliament is not in session and a emergency law is needed, a ordinance can be passed and the law can be made. So article 123 talks about the law making power of the president, and article 213 talks about the law making power of the governor. So here article 53 says that the president is the head of the union government. He enjoys ordinance making power. So when can this power be used? Whenever he feels that a law is immediately needed. He can, and the parliament is not able to do so. The parliament cannot legislate because it is winter session is going on, monsoon session is going on, immediate need is there for the ordinance. So then a temporary law can be made with immediately, and it will have an effect. Now when I say temporary law means validity is till when? Validity means what? The validity of that ordinance will be, the ordinance will automatically cease to have effect at the expiration of 6 weeks after the reassembly of the parliament. So once the parliament has met, after 6 weeks it will be invalid automatically unless they have made it invalid much before that. Same is with the power of the governor, but only thing it is for the state, and that is for the entire India. Now is the doctrine of pith and substance. Let's understand what is the doctrine of pith and substance. Very good. Now doctrine of pith and substance means what? When I say go to the pith and substance, go to the core. This is with respect to interpretation, core, or go to the main essential character. Let's understand what is this exactly. Okay, let's understand pith and substance. So remember we had done article 246 read with schedule 7. In that it had stated that there will be 3 lists, list 1, list 2 and list 3. List 1 is your union list, list 2 is your state list, and this is your concurrent list. Matters given in the union list, only the central government can make the law. Matters given in the state list, only the state government can make the law. And matters given in the concurrent list, both the governments can make the law. Till here it is clear. Very simple, we've done that in school also. But there are some matters which are very much bordering, which can overlap both the things, which are on the borderline. Matters which are on the borderline, which we don't know whether the central government can make the law or the state government can make the law. So we are confused that this matter is touching upon both the list. Union government is there, but it is also touching upon the matters on state list also. So who is allowed to make the law, whether the union or the state? So then they say, please go to the pith and substance of the law and see that what is it, whose core essential character it is, whose main feature it is. Accordingly they will get. So let's take an example. In the broadcasting aspect, okay, broadcasting and loudspeakers were given in Union List 1, and State List had a matter which was talking about public peace and sanitation. Public peace. Now, what happened is, so there were these two matters were there. Now, the state government made a law for banning loudspeakers at night. So, banning loudspeakers at night. Now, you tell me whether the central government or the state government can make the law. State government made a law. So then they said that, see, the state government made the law with not intention for broadcasting and loudspeaker. The pith and substance, the main character of the law is to maintain public peace, to maintain calmness, that loudspeakers should not be used at night. So then the pith and substance of the law was seen, and it was found that the state government is well within the right to make that law, because the main object, pith and substance, was public peace and sanitation, which was under their list. Till here it is clear. Okay. Then comes your and this name of this case law, which is also asked in exam, was your Chawla versus State of Rajasthan. Next, if we see doctrine of colorable legislation. Now, what do you mean by the doctrine of colorable legislation? Okay. So, first, colorable means what? In very simple, I'll tell you. In the color of doing something legal, you are trying to do something illegal. In the name of doing something good, you are doing something bad. So such things is not allowed. So if a government doesn't have a right to do something, but they will twist turn the words and try to do something which is illegal. So law has said that it's a colorable legislation and law can strike it down. So in this example of Kameshwar Singh versus State of Bihar, so colorable means on मतलब कुछ तो गड़बड़ है. There is some thing in it that it looks valid, but when you go deeper into that, you will know it is invalid. Okay. So in this, what they said. So what did they say in this? That in this, what did they say? That Bihar Land Reforms Act, in this case, they said that the Bihar government will take uncleared rents of tenants, and they will give 50% to landlord. So this, on the color, on the face of it, looks, it's such a good act the government is doing. They are doing recovery for the landlords and giving to the landlord the money. But, and the government is also saying we are helping the landlords only. But how? What is the problem here? Can you tell what is the problem? The problem is they are giving only 50%. So this is really showing that you're not taking, but you're not giving us, but you're taking away our 50%. So this kind of law, where they show that they are trying to help, but in reality they are looting the landlords, it was held to be colorable legislation, where the main intention was to take away the 50% of the dues. So this was in Bihar Land Reforms Act. Unpaid rents of the tenants shall vest with the state government, and only half of them will be paid back to the landlord. So the landlord said that this is invalid. On the face it looks nice, but in background you see what is happening. So that became invalid. Now all the others you can read it up. Now it's just general information. I'll go faster on this. Article 15. As we saw all the important articles, now we'll just go through the others. Article 15 talks about prohibition of discrimination on the grounds of race, religion, caste, sex, etc. Okay. Have you seen that movie Article 15? Article 15, where it says that we should not discriminate on the basis of religion, race, gender, caste system, etc. So the state government shall not discriminate against any religion. Lays down that no citizen shall be subjected to any disability, restriction or condition with respect to accessing any restaurant, public, well, etc. So earlier there was a lot of discrimination, etc., where they were not allowed to go to certain when you go abroad, blacks were not allowed. So maybe those who they were not uh, of certain thing. So there is a lot of discrimination with respect to color abroad. So if you're dark, they might not allow you to enter into restaurants, but that was long time back. So even in India, this kind of a law is there where anyone is being discriminated on basis of religion, caste, gender, they are doing something wrong. State government shall not do this. Article 16 talks about equality in employment matters. So there is also a law that was passed, which is state of Karnataka versus Uma Devi, that in employment also there has to be equal pay, equal wages, and equal opportunities for men, women, everyone, and they should not be discriminated on the basis of same caste, religion, gender, etc. Article 17 talks about abolition of untouchability. So we don't want this kind of untouchability mindset ever there. So this has been completely abolished, and law says that any act which is done which promotes untouchability is invalid. Abolition of titles. So earlier times we used to give the titles such as Mahatma, Sir. Now all this creates discrimination only because we used to feel these people are very high and others are low. So it could cause inferiority complex or discrimination. So law said that you cannot give any titles, neither can take any titles from foreign countries except with the permission of the government. However, giving Bharat Ratna, Padma Bhushan, all of this is all national amounts, does not amount to violation of Article 18. Then Article 19 to 22, we read all of them. Article 19, 20, 21, 22, all of this we've read. Then we saw right against exploitation. So this also you can mark it as important. You can read it up more from the module as well. That means you cannot trade how you trade in goods. You cannot trade in human beings. You cannot force someone to do labor. So Article 23 and 24 is something important that you also have to do, which we'll be doing a little later. It is a past exam question. Write a short note on right against exploitation. So exploitation in trafficking. Trafficking means buying and selling of human beings as you do of things. That's not allowed. Child labor, not allowed. Prohibition of employment of children in factories. Article 24. So remember this. Article 25 to 28 talks about freedom of religion. 29 to 30 talks about cultural and educational rights. Now this is not important from exam point of view. That's why I'm going a bit faster. Now if you want to amend your fundamental rights, then Article 368 in part 20 of the Constitution deals with the manner in which you can amend the fundamental rights. Here we don't have it much in detail, but you have to remember one thing, that you can amend the Constitution as you want. This was gone to the full bench of the Supreme Court. You can amend the Constitution, but you can never amend the basic structure of the Constitution. The basic structure of the Constitution can never be abrogated, changed, modified, etc. as held in the Keshwanand Bharti versus State of Kerala, where a full bench was sat. Now, what is the basic structure of the constitution? India will be supreme, constitution will be supreme, separation of power, secularism, federalism, judicial review, all these things are there. That it will be a welfare state. So all the right to equality, all of these are the basic structure of the constitution. The basic structure can never be amended. Everything else can be amended with Article 368. Now we know that the judiciary, not all important from exam point of view. We have the High Court, we have the Supreme Court, and we have subordinate courts. Separation of powers. Again, just a small, not very important, never they've asked. We know in our civics also we've read that the powers are different from the legislature, judiciary, and the executive. The executives are the police who implement the laws. Judiciary is the one who interprets the law, and the legislature, they pass the law. So they pass the law, they interpret the law, and they execute the law. Execute the law. So legislature is your parliament, interpretation are your courts, and execution is your police and enforcement agencies, authorities, etc. Okay. Then they talk, now all this they've never asked, but still we just quickly go through the law making process. If you want to make any law in India, we all know a bill will be passed first. So we have the Companies Bill, then it's published in the Gazette. You have 3 readings of it. A committee will be made. Then both the houses of the parliament have to approve. President's assent will be given, and then the act will become the bill will become an act. Now there are certain committees that can be made, certain parliamentary committees. Now parliamentary committees, now all this is not very important, they never come, but quickly I'll go quickly. The committees aid and assist the legislature in discharging its duties and regulating its function effectively. Through the parliament committees, they exercise control and influence over administration. Now let's see what they are. Ad hoc and standing committee. Standing committee is a permanent committee, regular committee which is always there. Ad hoc committee is a committee made for a specific purpose. Once the purpose is over, it will be shut. Now all this is not important, never asked, but still I'm telling you just in case if they ask. Okay. Then the government also has other committees which can be used as watchdogs to see if the proper expenditure is being spent on it. Then we said as a bill. Now bill is a draft statute. It requires both the houses assent and the president's assent. There is ordinary bills and there is money bills. Now what is ordinary bills? Very simple. Anything which is not concerned with financial matter is an ordinary bill, and anything which is concerned with money matters is called as a money bill. In money bill we've heard of Finance Act. So Article 110 deals with that, the taxation aspect, public expenditure is there. A money bill is a specific kind of financial bill. So if it doesn't talk about money, it's an ordinary bill. If it talks about money, then it's a money bill. Now money bill contains about taxes, about government borrowings, about the consolidated fund of India, where all it will be used, where all they will receive the money, and where all it will be bifurcated. Now we come to finance bills. Finance bill is a wider concept. It includes a money bill. So finance bills have wider concepts. It includes a money bill. Only difference is finance bill doesn't necessarily have to talk about tax. They can also talk about fines, imposition of fine, penalties, demand of fees, etc., which is not there in money bill. So finance bills could be a money bill which talks about tax and expenditure and others. So others is basically for fees, fines, etc. Clear? So both, so money bill is a wider concept. Okay. Then there is one article 301 is not very important. Then let me just skip it. Never come, but I'll just tell you in short. Article 301 says that any state can do and freely do business throughout the territory. Trade, commerce. Constitution provides that the free trade, commerce, and intercourse should be free throughout the state. However, imposition of octroi tax, entry tax is okay, and toll tax is all valid. This is what they have said in this case. Okay. The reason is it is important for maintenance of the roads, etc. So that is it. We are done with the entire constitutional law. I'll take you all through the exam questions once, and then I'll just take you first. I'll take you through the supplement. This sheet is supplement sheet is there. In this, they've added one case for constitutional law. Very simple and easy. I don't think it can come in the exam. Skill Motor Solutions versus Union of India. Here, what happened? GST was levied on lottery. GST is levied in lottery. So I teach GST also. So if you read rule number 31A of the valuation rules, valuation of lottery is done. So it was said that it is violating article 14, 191G, etc. because extra taxes are being put on them. So they said why this discrimination, etc. However, it has been held in this case that it is perfectly valid, that levy of GST on this is not discriminatory. So this is one case law for constitution in the supplement which we have completed. Now we'll just quickly see whether the exam questions we have covered or not. So these are the exam questions for your constitutional law. First, discuss the test laid down by the Supreme Court for deciding whether a thing is a state or no, instrumentality of the state. So you've done that in Khalid Mujib case we have done. Then they've asked explain the restrictions of freedom of speech and expression. That also we've completed. Then they've said discuss the word procedure established by law under Article 21. I told you that has to come. 19, 20, 14 or writs. One has to come in the exam. Then in June 21 they have asked freedom of association, Article 19. And what are the reasonable restrictions on them? So that also we've discussed. Article 14. So I told you it has to come. It has been coming even when we were in law. Prepare it well, okay? Then they've asked this case, or in December 19, Rajasthan legislature passed a bill restricting sound amplifiers. So same thing which I had said, it was a doctrine of pith and substance. Then write a short note on quo warranto. Quo warranto is writs. That is also there. We've done. Then came doctrine of eclipse. We just did that. Then came Article 19(1)(g). Again, all citizens have a right to practice their business and profession. Explain. That also we've done in great detail, along with lot of case laws. Okay, so you have to write your case laws also. And in June 2021, they've asked about Article 21. Can anyone tell me what is about Article 20 sub Article 1? Obviously, it talks about ex post facto law, protection against ex post facto law. Then they've asked with respect to striking down as invalid article doctrine of severability. They have asked in the last attempt article number 13 as well. Then under the constitution, the parliament is empowered to make a law even on the subjects enumerated in the state list. So this is all when the center can make laws on the state. So all these points, national interest, proclamation of emergency, breakdown of constitutional machinery, we've done. Okay, this we've done international law. Then in December 2021, briefly describe the fundamental rights against exploitation. Now this we've done prohibition of traffic in human is article number 23. It imposes a ban on traffic in human beings, beggars. We've seen the traffic signal movie where they sell and trade babies. So the child which cries the more is rented out for a higher price. So all that is wrong. So the traditional system of beggary has become now unconstitutional. Now traffic in human beings means dealing with men and women like how they would deal with goods. Then prohibition of employment in children. So we are talking about children below the age of 14 are not allowed to work in any of the factory, mines, etc. The Supreme Court has laid down guidelines in the MC Mehta versus State of Tamil Nadu. Then article number 16. What does article number 16 talk about? Explain the reservation policy. So article 16 lays down equal opportunity of employment in public sectors. Parliament can make a law in respect of with regards to class or class employment. Can make certain reservations also, can make reservations for promotion. So all these parts, article 16 you can read it, and that is it. We are done with constitution along with all the exam questions, and whatever you feel you can mark it down and read it up more in detail. Clear? So we are done with constitutional law also. Okay. It was asked once in the exam, so you can read it up since it's an exam question. Now we will take another break and we will start with the third chapter. Which chapter do you want me to start with? Just before that, let me tell you, with respect to Arbitration and Conciliation Act, you all can message me which chapter you all want me to take, otherwise I'll go in interpretation of statutes only. One is Arbitration and Conciliation Act. Very, very, very important. This chapter, if you search on YouTube, okay, just search on YouTube. My video will hopefully pop up on the top ones. Arbitration Conciliation Act CS Executive. There I have covered with all the amendments. You need to cover this video, this chapter from there. Okay, and if you are finding it difficult to find it, I don't think you should find it difficult, but I will put it in the description then. CRPC, done. So I'll take immediately CR. Please message me the chapter names that you all need. I will take it up. So I've finished two big chapters. Arbitration Conciliation Act, you need to do it from my YouTube lecture on YouTube. Go and search Arbitration Conciliation Act CS Executive. My video will pop up. Full completely I have covered that chapter in complete detail. Clear? So just message me which all chapters you all need. So once let me see with the weightage of the marks, special courts, okay. Which other chapter? So I'll take it up next. I'll take CRPC. Okay, quickly if you all can message me if you want any specific chapter. The specific quotes are there, but it's not of that much weightage in the examination. CRPC, CPC comes in the part A chapters. Okay, so even penal code, evidence, CPC, CRPC. So CRPC I will take next. Okay, so I will take CRPC. So we'll take a short break. Time. So at 5, Stamp Act. Okay. Now Stamp Act also, if you just, I put Stamp Act also, just YouTube it, put Stamp Act CS Executive, my video will pop up. Yes. So I am going to take CRPC. Okay. CRPC I will take it. Clear? So we will return back. So this and Stamp Act, both I have updated it, and Stamp Act. Okay. Now I'm going to take a break. So we'll take a break, and before we start the CRPC, I'm waiting. IPC. Okay, so CRPC is a constant question. by all of you all. So CPC, CRPC, I will take it next. Okay, so let me just search if I can find CRPC. Okay, so which chapter number is it? Okay, so I think I found it, and I'm also going to take the exam question. And thank you so much. You are sitting for so long. It's a pleasure to see you all sitting and bearing the lecture for so long. Which chapter number is it? 8. Just finding it. Okay. So I will start with CRPC. Just let me come to it immediately. CPC, CRPC, I'll finish like this. Jishnu, how much do you want? I will sit till then. Criminal procedure. Okay. Actually, very good because both. So both actually the CPC is also 10 marks and CRPC is also 8 marks. So I think I will go for CPC, CRPC next. Quickly, I'll finish it off. Oh, actually, we should do this. CPC, CRPC. I will cover it up. Okay, let me just skip this and that. So we return back at 5:30. 5:30 is better. Let us find it. So these are the exam questions of CRPC that we'll be doing, all the exam questions along with the model answers, and this is the entire chapter. So we will resume at 5:30. So at 5:30 p.m. we resume. Take care. So I'll see you all at 5:30. Hi guys, am I audible to y'all? If y'all can just message on WhatsApp, it will be great. Oh, sorry, on the chat box, if you can message if you can hear me clearly. Okay, so I'll quickly continue. I'll go a bit more fast and cover more important points so that we'll try to cover CRPC, CPC, and IPC as I've just seen. Okay, so all the three I intend to cover it. Okay, so let's begin. Good. Okay, great. So you all have said CPC, CRPC, and IPC. So let's target that and finish it. Keep your book and pen ready and we will finish it. Okay. Chalo. Let's start. First, we will start with the Criminal Procedure Code, CRPC. Let's understand in law, there are something called laws can be divided in two parts. One is substantive laws and another one is procedural laws. Now substantive laws are laws which gives you the rights, mention the rights, and gives you the definition of various things. This example of that is constitution, your contract act, etc. Your company law, etc. are substantive laws. Procedural laws tell you the procedure to be followed. Another example here is IPC, Indian Penal Code. Procedural laws tell us what is a procedure to be followed in these laws. So we have civil matters and we have criminal matters. For civil matters, we have something called as CPC. And for criminal matter, the procedure is laid down in your CRPC. Clear till here? So we will target to finish IPC, CPC and CRPC. Till here it is clear. So your CRPC 1973 is a procedural law which contains a procedure with respect to criminal law. Now, we will see a few important definitions. Normally, offense simply means whenever you act, you have done a thing which is punishable by law is called as an offense. So a person has done so and so offense. Now, the IPC contains the main particular list of offense: murder, dacoity, theft, you have terrorism. All of those definitions are given in the IPC. If you have done an act which is mentioned in the IPC, it is concerned as an offense. So whenever you do an offense, then the procedural law will apply on what is to be done. For example, you see a murder, what is to be done, then you will call the police, FIR will be made, accused will be called, arrested, bail, all those things will come. Now mens rea. Mens rea, I think all of you all know, it means a guilty mind. Mens rea is needed in criminal offences. Criminal offence. Let's understand. Mens rea means the intention. If I have done an act with the intention to do the offence, I can be termed as a criminal. But if there was no intention, there is no crime. Now, offences can be divided into two parts. One is bailable offence and the second one is non-bailable offence. What do you mean by the term bailable offence? So if you see the definition, it says that a bailable offence is one which is shown as bailable in the first schedule. So in the CRPC towards the end, there is a first schedule. So in the schedule, if you go to see, they will give you simple hot. It's an offense. The name of the offense will be given here. Then they will say whether it is bailable or non-bailable. They will tell whether it is cognizable or non-cognizable, and then they will tell whether it is compoundable or non-compoundable. Okay, so let's see. Cognizable or Non-cognizable. Now you tell me, normally simple hurt, just pushing someone which does not extend to more than 3 days pain. So law will say there will be a tick on bailable offence, that it is bailable. So in the first schedule it will be shown as bailable. Now cognizable, cognizable, the word cognizable means serious. Cognizable means serious. So tell me, a cognizable offence is a serious offence. So this is a serious offence as compared to murder. In murder, it will be written it is non-bailable and it is cognizable. Okay, whereas for this thing, it will be written that it is bailable and non-cognizable. So non-cognizable means non-serious. Okay, in non-serious offences, the police officer cannot arrest the person without the warrant. In cognizable offences, serious offences, what do you mean by, how do you say it is serious? The police officer can arrest the accused without a warrant. A warrant is a permission of the court. For example, if you found a terrorism, it is a cognizable offence. Police officer doesn't have to go to the magistrate to get an order to arrest the person. Clear till here? Non-cognizable means an offence in which the police officer has no authority to arrest without a warrant. Next. Now, very important. I don't know whether you must be knowing this. Now, whenever it is a cognizable offence and when it is a non-cognizable offence. Serious offences means cognizable. It's a serious offence. I don't know whether you've ever gone to the police station to put a complaint, etc. Have you ever been to the police station? That time you realize that whenever you report a cognizable offence, the police officer will normally issue a FIR, first information report, okay, which if you see, you go and tell that the mobile has been stolen, generally they can write a FIR, XYZ goods have been stolen. So FIR contains the first information when you reduce that certain cognizable. So every information relating to a cognizable offence shall be reduced in writing by the police officer. Every information shall be signed and given to the person. So you get a copy of the FIR also. It is read out to the informant also. But whenever there is a non-cognizable offence, non-serious, the police officer will issue a NC, non-cognizable. NC also you must have heard. It is a non-serious matter. That means the he's just issued it. Police officer is given a warning. He will not further investigate into the matter till the court has ordered him. Clear? So for this they've given you about FIR and NC. Okay. Now 155. So 154 talks about FIR. 155 talks about NC. NC being issued. Whenever you report a non-cognizable, he shall mention it in his book. Okay, the police officer shall not further investigate into a non-cognizable case. Yeah. Now, time limit for taking cognizance of certain offences. Now, law has also given certain time limit. We know there is a limitation period for filing complaints. In general, there is no limitation of time in filing complaints under the Indian Penal Code. But the delay may hurdle the case. Indian Limitation Act provides time limit for appeals and revision applications. Except otherwise provided in the code, no court shall take cognizance of a matter after the expiration of the time limits mentioned below. So, as there are time limits to report an offence, same way, the court shall not take cognizance. The court shall not take recognition shall not take up a matter if it is come after the expiry of 6 months in case of offence which is punishable with fine only, 1 year if it is punishable with imprisonment not exceeding 1 year, and 3 years in case if the imprisonment is exceeding 1 year but not exceeding 3 years. So they have given you the timelines: 6 months, 1 year, and 3 years. Now, coming to the meaning of complaint, what do you mean by the term complaint? So, complaint is a allegation. When I complain, I make a allegation. Now, this allegation is made to the magistrate that I don't know whether you know or you don't know who has done the offence, but an offence has been committed. That a offence has been committed, and I don't know, I may or may not know the person. So section 2D defines the definition of complaint. It says complaint in criminal cases is what a plaint is in civil cases. So whenever we make a application in court, it's a complaint in criminal courts, but in civil matters we call it as a plaint. Complaint is there is an allegation that a crime has been done and is made to the magistrate, and with the object that action should be taken. Now coming to bail. Okay. What do you mean by the term bail? We must have seen movies and many times. So bail is a release of a person, release of an accused from police custody to private custody, from custody of the officers of law to a private custody. But court will not just leave a person, they will take a surety. So there will be sureties who will guarantee that this person will come to the court on the specific time and date. I take responsibility. Now obviously court gives bail only in bailable matters and in non-bailable matters only when the court feels that the accused will not run away, abscond, leave India, etc. Okay, so this is about bail, definition of bail. Next comes meaning of anticipatory bail given under section 438. What do you mean by the term anticipatory bail? Anticipation means what? मुझे लग रहा है, I feel, there is an apprehension, there is a feeling that I might get arrested, and for that I am making a bail application before being arrested. So what do you mean by anticipatory bail? It means making a bail before arrest. Now how can that be possible? Any idea? Have you ever heard? I have seen many times ABA being filed. They are called as anticipatory bail applications, ABS. So let me give you an example. Let's say if there are a firm, the multiple examples I can give you. At any point of time you feel that an example needs to be given, please mention in the chat box that you require an example. Okay, I'll give you. So let's say there is a partnership firm, and this partnership firm has 3 partners. So there is partner A, B and C. For some reason there was police has arrested Mr. A for cheating, allegation of cheating, and they have arrested Mr. A. Mr. A's lawyer will apply for bail, but B and C have yet not been arrested, but they will anticipate arrest. They will feel for some reason the police will also come to B and C. So in advance only, court will the lawyers will say that a FIR has been filed, but the arrest has not been made of B and C. They are innocent. We have all these proof. Please give them a bail. So then the bail will be granted. This is called as anticipatory bail application. Clear? Now, anticipatory bail application is granted by the High Court or the Court of Sessions to a person who apprehends. Apprehend means thinks, believes or predicts an arrest for having committed a serious offence. See, if it was a bailable offence, then nothing to worry. I will, whenever it is there, I'll take a bail and leave. ABAs are filed only in non-bailable offences and he has not yet been arrested. Section 438. Next comes to three stages of investigation. One is an inquiry, investigation and trial. So the first stage, there are three stages: investigation, inquiry and trial. Now pay attention to this. Investigation is when the police, so this is the first stage, this is the second stage and this is the third stage. So first stage is when the investigation, when the police officer in a routine check is investigating into a case. Show me your documents, what it is. Now he doesn't have any proof. He's just asking for information, normally investigating. On investigation, if he finds something wrong, or he finds something fishy, or he finds something prima facie wrong, on the start उसको लग रहा है कुछ गड़बड़ है, he will then go to the next stage and he will do a detailed checking which is called as inquiry. So if he finds no offense, so matter gets over. But if he of the opinion, but if he is of the different opinion, he sends the case to the magistrate and begins with the trial or inquiry. And after inquiry, if he finds that still something is wrong, then he will go to the third case is trial in court. When then court will decide, magistrate, that is the judge of criminal courts are called as magistrate, will decide whether he will be released or not. Next, we go to a pleader and we see public prosecutor. Can you tell me this Ram Jethmalani is a pleader or a public prosecutor? I want you to put in the chat box that Ram Jethmalani, he is a very big criminal lawyer. I believe all of you all must be knowing. Is he a pleader or a public prosecutor? Quickly, PP. Is he a PP or is a pleader? So a pleader is anyone who's pleading to get the accused out. Either the accused himself is allowed to plead or the accused criminals, allegation, whoever is there, his lawyers. So any person allowed to plead with the permission of the court is called as a pleader. Very good. So here this is Ram Jethmalani. A public prosecutor is there in the court only. He objects all bails, all anything. Whenever the criminal's lawyer is coming, the PP fights. So he is generally in the court only. He is in the court only. So PP is any person appointed to act as a public prosecutor. So he is helping the public by ensuring that the criminal goes in jail. So PPs object to bails, puts the person in jail. Clear till here? Public prosecutor through generally public prosecutors are in the court and they serve the court for 10 years, 15 years and they become judges. Okay. Now let's go to the next thing, summons and warrant case. Summons case and warrant case. Summons is a chotu case and warrant is a serious case. Now how do you define it? So if the matter is up to 2 years, if you have done an act or an offence for which the maximum penalty is up to 2 years, then it is a summons case. Summons case means a case not being a warrant case. Warrant case are all those cases which imprisonment is more than 2 years or life sentence can be done or death penalty can be given. That means you've done something, or the accused has done something really wrong. So warrant are bigger, more criminal matters. Clear? Now, summon case means a case relating to an offence and not being this. Now let's understand what is warrant case. Warrant case means a case relating to an offence punishable with death, very serious, punishable with life imprisonment, punishable with a term exceeding 2 years. Clear? So this is warrant case. Everything else is a summons case. Normally, summary trial is of summons case. Now, classes of criminal courts. Classes of criminal courts. Now, if we go to see, the biggest criminal court is your High Court. Then below the High Court is the Court of Sessions. Then below that, then you have the JMFC, Judicial Magistrate First Class. Then you have the Judicial Magistrate Second Class. And then you have the Executive Magistrate. So we have criminal courts in India. These criminal courts have hierarchy. The lowest is executive. Then there is GM second class. Then above that there is Judicial Magistrate First Class, Court of Sessions, and then High Court. All of them get certain powers to give. So all these courts get, the bigger the court, bigger penalty they can give, bigger fine they can levy. So your power of courts to pass sentences, High Court can pass any order, any criminal law, okay, any sentence authorized by law. A sessions judge, so sessions judge may pass any sentence, but for death penalty he has to take confirmation by the of the High Court. Then a sentence which the magistrates may pass, so then they have given you JMFC, what imprisonment term he can give, 3 years and fine up to 10,000 or both. Then the second class, he can give punishment up till 1 year and a fine not exceeding 5,000 rupees or both. So one, you can check the limits. Now, whenever the court orders a fine, is it necessary that the accused will be able to pay the fine always? Tell me. If the court has given a fine, you think always the accused can pay the fine? Yes or no? Yes or no? Can the accused always pay the fine? Answer is no. There can be default to pay fine. In that case, what we do? Then nobody will only pay. So what we do, in lieu of fine, we give him more imprisonment. Means we will tell him you can't pay fine, na, more jail you will get. So now how much jail can be given? Let's say the accused could not pay 5,000. Can we give him a jail of 10 years? They will say no, wait, the limit has been given. So the imprisonment awarded in lieu of fine, okay. So when a fine is imposed on the accused and it is not paid, he can be imprisonment for an additional imprisonment can be given to him. So where the imprisonment has been awarded as a part, it should not exceed 1/4 of the term of the imprisonment which it is competent to inflict, otherwise then as a imprisonment in default of fine. So let me tell you simple. If accused, so he can get maximum imprisonment for default of fine is equal to 1/4 of the maximum penalty for the offense. So how much is the max? So they had asked once, what is the maximum imprisonment we can give for default of fine? So they are saying 1/4 of the maximum penalty for the offense. For example, the offense, the maximum penalty on this, for example, might be 3 years, 36 months maximum penalty. For that offense can be given is 36 months. So what is the maximum imprisonment that can be given in default of fine? Will be 1/4 of this amount will be equal to 9 months. Is this clear? Is this clear? So the maximum imprisonment that you can give for default of fine is 1/4 of the maximum punishment for that offense. Next, arrest of persons. They have asked this in the exam quite a number of times. Okay, which is your exactly 9 months extra. Now, arrest of person, section number 41. That a police officer may arrest a person without an order or without a warrant in the following cases. Can you tell me, they've asked that when can a police officer arrest the person without a warrant? So so we had read earlier, whenever the person has done a cognizable offense, serious offense. Second, if he's done housebreaking means he's theft. While doing the theft, he's entered into someone's house. Housebreaking, the police officer can arrest without a warrant. He's a proclaimed offender. Proclaimed offender means नाम इनाम रखे उनके सर के ऊपर, or there is a proclamation that there is a reward given on his arrest. In whose possession anything is found which is suspected to be stolen property. So in your possession I have found stolen property, so you can be arrested as well. Who obstructs a police officer, who is a deserter from the armed forces. A reasonable suspicion exists that he has committed an act at a place outside India. Someone has done an offense outside India, has come into India, so we can arrest him. Who is being a released convict, commits the breach of his rule. So he's come out from parole in jail, he just come out for good behavior and again he did a crime. So again he can be arrested without a warrant. And for whose arrest any requisition has been received from another police officer. One police officer has told the other one, arrest him quickly. So don't read, that other guy has to follow the command and arrest. He doesn't have to wait. Clear? Then comes summons. So first, how does the procedure work? Let's break it down. How does a criminal procedure work? Very, very simple. Moment someone files a complaint, we read in section 2D, complaint has been filed. The court will summon the accused. So there will be a summons. A summons will be delivered. A summons will be delivered to the person. And this summons will be delivered to the person. If he is not taking, again it will be given, or it will be stuck at some conspicuous place at his house. It will be stuck. If he is still not coming after the service of 2 summons also, then a warrant will be issued. A warrant is a permission by the magistrate. A warrant letter will be there where the details of the court, details of the officer and details of the accused and the crime he has done. A warrant that go ahead and arrest him and come. खुद से नहीं आ रहा है वो. He's not coming by himself. After the warrant, still that person is not coming because he's hiding underground. Then we have to proclaim him as an offender. Proclaim him as an offender. That find him, whoever finds him will get money. Still, if he is not there, then we have to attach his property. Attach property. This is the maximum that we can do. So we'll issue a summons. If he still doesn't come, then we'll issue a warrant to arrest him and get him. We will proclaim and attach his property. Search warrant. Many times it has come in the exam. What do you mean by search warrant? Section number 93 talks about a search warrant. Search warrant simply means warrant. It's an English word which means permission, or warrant means a power. Power given by the magistrate that search XYZ person. Now, why will a search warrant be given? Now, if a person has stolen and hidden the goods, we need a search warrant. So, a search warrant can be issued by the court in the following cases, where the court has reasons to believe that the person summoned to produce any document will not produce it. उसको बोला है कि document लेके आओ. We told him to get a document, but he's not going to get. So warrant, this can be issued. Second, where such document is not known to the court in whose possession it is there. So a thief, robber must have stolen the property and hidden in someone's house. We don't know in whose house he has hidden. So we will order, the court is not known to the court in whose possession. They will order a general search warrant. Third, where a general inspection court feels is necessary. Okay. However, a search warrant may be general or restricted in its scope, so they will restrict, etc. Then comes unlawful assembly. Unlawful assembly is when five or more persons have got together and they may breach there may be public peace. So then the officers will come that all of you all have gathered together and doing protest. It is disturbing public peace. It is bringing a big issue. So they will declare that assembly as a unlawful assembly and ask them to go away, to disperse. निकल जाओ यहाँ से. So they will ask him to disperse. If such person does not disperse, if he doesn't go, then may proceed to disperse such person by force. So if he doesn't, if the team does not disperse, they will tell him to disperse by force. Then comes public nuisance. Now public nuisance क्या होता है? Section 133. It says that the following public nuisance can be proceeded against. Public nuisance means harassing the public, annoying the public. कैसे? So by all these things. If you are creating a unlawful obstruction or a nuisance to be removed from any public place, river, channel, etc. used by the public. You went to a beach and you made your own stall. It is obstructing others. In the river, you're making your own shacks or you're making your own boat. Taking out all these things is a public nuisance. You are carrying on any trade which is injurious to health without proper license. You're storing explosives, etc. All of this is injurious to health. Next, construction of any building which is likely to conflagration or explosion, which can explode, building tent or near a public place, or taking any dangerous animal. All these things, it is called as public nuisance. Now coming to summary trials. Now what do you mean by summary trials? Summary trial means a speedy settlement of disputes. It means speedy disposal of cases. It is meant a case which will be immediately tried and disposed of at once. It will apply to offences not punishable with imprisonment exceeding 2 years. As you remember, summary cases were cases which were up to 2 years imprisonment. So in such cases, court can say, okay, fine, let's just chota matter hai, so without going into detailed evidence, let's end it. So such offences shall not be punishable with imprisonment exceeding 2 years. Such offences can be summarily tried. तो जो ऑफेंस किया है जिसका मैक्सिमम इम्प्रिजनमेंट इज 2 years, उसको हम लोग फटाफट सेटल कर सकते हैं. बट जब भी हम लोग फटाफट सेटल करेंगे, whenever we quickly settle, you have to remember that the imprisonment that you're giving shall not exceed 3 months, because you're not going into detailed evidence. That offense is, you could have given imprisonment up to 2 years, but since it is summarily tried, the maximum imprisonment you can do is 2 years. They've given you entire cases on when summary trial can be given. So this is important. Next, they have given you certain inherent powers of the court. Section 482. Inherent powers of the court means what? Of the High Court. Normally, High Court does not interfere with the lower court's functioning. But at any point of time, if we feel that a wrong FIR has been filed, wrong allegations has been filed, High Court has a power to interfere and squash those decisions. So, it is deemed the powers of the High Court under Section 482 are partly administrative. So, in many times we've seen that you can so whatever is given in the CPC, in the CRPC, it cannot limit the inherent powers of the High Court. The inherent powers of the High Court is that they can squash FIRs. I don't know, I've personally been dealt in a matter where there was squashing of FIR. Okay, here this is called as inherent powers under section 482 include the power to squash FIR. If a wrong FIR has been filed, you can set aside it. However, the High Court should use this power very sparingly and with caution. सोच समझ के rarely use करना है. Now, Supreme Court in Madhu Limbe versus State of Maharashtra has held the following principles govern the inherent powers of the High Court. High Court can squash the FIR, but they should very rarely use it. Should not be resorted to if the party has a specific remedy where they can go and appeal, etc. Then we will say go and appeal. We will not directly squash or take up the matter. If a remedy is there, then we will not use the inherent powers of the High Court. It should be used very sparingly to prevent abuse of the process of law. Okay. It is well settled that the inherent powers of the court can be exercised only when no other remedy is available to the litigant. So we are done with the CRPC, the entire thing. Now we'll go through the exam questions to see whether we've covered everything or not. Okay. So this is your exam questions, whatever has been asked in CRPC till now. First, discuss summary trial. So we've done summary trial now. Summary trials are speedy settlement of disputes, offences or acts which can attract punishment not exceeding 2 years can be summarily tried. They've given you certain offences which can be summarily tried, and the maximum imprisonment that can be given in summary trial is 3 months. Next, distinguish between cognizable and non-cognizable offences. So we've done that. In cognizable you have a FIR, in non-cognizable you have a NC. Next, enumerate any 4 categories of cases where a police officer can arrest without a warrant under section 41. So we saw all those cases. Next, describe in brief the cases in which search warrant can be issued under section 93. So we've seen all those cases. Then discuss the provisions relating to information to the police officer and the power to investigate in cognizable and non-cognizable. So section 153 and 154 and 155. We've done that in the start. FIR is 154, NC is 155. Then December 2020, section 41 again has been repeated. Then comes complaint. Complaint section 2D, they have given you the definition of complaints. Then come June 2021. Now the latest case was requisites of a warrant of an arrest. So for warrant they had said it should be in writing, the who's going to execute will be given, कौन पुलिस ऑफिसर है, कौन जाएगा, किसको अरेस्ट करना है, कौन से ऑफेंसेस है, कौन सा चार्ज किया है, who is the officer, who is the judge, magistrate, and it will be having the seal of the court. Discuss the provisions, the power to issue order in urgent cases in case of nuisance, apprehend danger under section 144 of the CRPC. This is one thing that you can read up. Extrajudicial confessions. This is in case of your admission and confession, which is there in another topic. Come here. It is there in another one more topic where admission and confession is there. The Parliament passed many laws. This is December 2021. Laws in the interest of public safety and social welfare. It imposes a absolute liability in criminal cases. So again, they are talking about the mens rea and all those conditions for mens rea. Absolute liability, mens rea is not essential. Now again, explain the provisions given under CRPC for publication and proclamation of absconding persons. That's also we saw. Discussion of under section 144. So this is something new that they are asking. So take a note of section 144 also additionally to be done. And that is it. So this is 144 is additional learning, and that's it. Clear? So we are done with CRPC also. Now if you all want, you all have to message me in the chat box whether you all want me to do IPC now or CPC now. Message in the chat box. Both I will go real quick, but you need to tell me whether you want IPC first or CPC. Both I will go fast, just a overview. But all the important exam questions we will cover. I'm waiting. IPC. What is the other? You'll need to message in the IPC. So right now I'm just discussing IPC at CRPC at the moment. We'll see the others also between these two. Okay. So we'll go for IPC first. Now understand IPC. I'm going to go quick overview in real quick manner that you can quickly know what all is there and you get a complete brush up. So just in 5 minutes we'll start your Indian Penal Code. Clear? Done. Okay, I'll definitely try to take that also. Not a very big task. You had said IPC, CRPC, and this, so I was taking that. Fine. Give me 2 minutes. And you added one more. Okay. So I'll be starting with IPC now. Got it. So IPC it is. Just loading it up. Till that time, you can also keep marking and finishing off things with me. So this will be a really quick revision of IPC. Okay. So just give me. We'll return in 5 minutes. Okay. You also just keep a track of what all you all need to know, etc. So we'll return in Done? So we'll start with Indian Penal Code. So in 5 minutes I'll return. Let's stop it, yeah. Full day like a madman. Guys, am I audible to y'all? You need to message if I'm audible to y'all. मेरा ये स्क्रीन देखो ना ये नहीं हो Hi, am I audible to y'all now? Okay. Thumbs up. So let's begin with your Indian Penal Code. So it'll be going to be a quick revision, but I can assure you from here only the exam questions will be there. Okay. So just quickly, am I audible? Yes. Great. So let's start. Okay. So firstly, from this chapter, the entire chapter covers only this much. There's nothing more. They talk about the introduction, they will talk about certain offenses, and then they will talk the general defenses towards the end. So your chapter is having only three parts: the introduction, the certain offenses have been given to you, and the general defenses of crime. First, in introduction, they've given you what is the jurisdiction of IPC, fundamental elements of crime, stages of crime, and punishments. Then they've given you all these punishments and they've said what defenses you can take in case you are accused of a crime. So firstly, we start the Indian Penal Code, the law of crimes in India. In India, you have civil law and you have criminal law. The criminal law in India is called as the law of crimes or your Indian Penal Code. Now, what is the purpose of having a criminal law? Criminal law is basically if you have violated anything, you can be put behind bars and ensure that there is proper justice. The main purpose is to punish the violators, regulate human behavior, and provide a punishment code in India. Now, origin, the code was drafted on recommendation under the chairmanship of Lord Thomas Babington Macaulay. It was passed on 6th October 1860 and came into operation on 1st Jan 1862. There is a separate structure. The structure of the code has been given. It is divided into 23 chapters and 511 sections. Now, criminal law, the substantive part of this law, that is the definition and the quantum of punishment, is given in the Indian Penal Code 1860, and the procedural part is given in the Criminal Procedure Code 1973. I'll directly start to what comes in the exam. Okay. So first, elements of crime. For anything to become a crime, a human being can only be accused of crimes. Animals do not come here. There has to be an act. An act includes mens rea, and it should have a intention, and that with that intention you should have done an act. Now, stages of crime. There are total 4 stages of crime. You need to tell me which stage is punishable. Having an intention to do a crime, then preparing for it, the actual attempt, and last is actual commission of the offense. So the first 2 stages are not punishable under law. Only an attempt or actual commission is punishable under law. Now all this is there, but it doesn't really come in your examination. I will tell what really comes in the exam also. The punishments, if someone has done a crime, Then punishments under criminal law is death penalty, life imprisonment, forfeiture of property and fine. Now, this is the part that you should know properly. The offenses all given, there are certain specific offenses given, and these are all these 7 offenses given and the section numbers here. So if you can remember this is well and good. Okay, let's see. First, the first offense that they are talking about is criminal conspiracy. Section 120A and 120B of IPC talks about criminal conspiracy. Firstly, let's understand what do you mean by the definition of criminal conspiracy. Conspiracy requires 2 or more persons. You cannot alone do a conspiracy. So, and it is a criminal. So, it's a conspiracy, 2 or more people coming together to do an illegal act. So, it is 2 or more persons agreeing to do an illegal act. Let's say killing someone. Or to do something by illegal means. Illegal imports. So, 2 or more people conspire, decide कि हम लोग कुछ चोरी करेंगे, that we will rob something, etc. So that's a criminal conspiracy. What are the essential ingredients for this as given by Venkat Krishnan versus CBI? There has to be 2 or more persons. They must have an agreement. That agreement will be to do something illegal or to do something legal but by illegal means. So importing of goods is legal, but I will do it by smuggling it into India. Now there was the parliament attack case which they had asked in exam, where what happened is there was an attack in the parliament and someone helped the accused to run away. Can that person be held for criminal conspiracy? Answer is no. Because there was no prior agreement. It just happened spontaneously. वही टाइम पे हो गया, कुछ पहले से डिसाइड नहीं किया. क्रिमिनल कॉन्स्पिरेसी में पहले से ही एक अग्रीमेंट होना चाहिए. बिफोर एंड ओनली देयर हैज टू बी an agreement to do an illegal act or to do a legal act in an illegal way. So in Delhi, in CT of Delhi versus Navjot Sindhu, the accused had never contacted the deceased terrorist. So there was a terrorist. This guy has never contacted him, but I just helped him flee to a safer place after the incident. It was held that he was not guilty of under this section 28. Then comes criminal misappropriation of property. You can write this word. This is nothing but theft. Criminal misappropriation. Criminal means there is an intention to do something wrong. Property includes cash or any kind of movable property. So when you take the goods, movable property from someone's possession and misuse it, it is called as misappropriation of property. So let's see section 403. Whoever dishonestly misappropriates or converts to his own use any movable property shall be punished for 2 years or more. Examples of misappropriation is what? I take away the goods and I go without your consent. So takes the property of Z without out of Z's possession in good faith, believing at the time that he takes that the property belongs to himself. He is not guilty of theft. If I thought it is mine and by mistake I took it, it will not be treated as theft because there was no intention. Okay, so then this is about theft. Then comes misappropriation of property by a deceased person at the time of the death. Now this is a separate section altogether, 404, where it says that if the person has died, then you ran and you took that deceased person's, dead person's belongings and you ran away, took the money and you ran away, then you will be charged under section 404, where you rob a deceased person. Okay, so X died in possession of certain furniture and money. His servant dishonestly misappropriates it, he will be guilty under this section. Now comes to another part. So you have to remember whatever I'm telling you, the key words you need to remember. Then comes your criminal breach of trust, section 405 to 409. Now understand, whenever I use the word criminal breach of trust, that means first there has to be a trust, एक trust होगा, that trust का तुमने misuse, you must have done a misuse of the trust. So criminal breach of trust, section 405 says whoever, first there has to be a trust, so there will be a entrustment of property. So whoever entrust with a property or with any dominion over the property. So I gave my goods to you, I entrusted the property with you, and you dishonestly misappropriates or convert to that use in violation of the directions given, you committed criminal breach of trust. So let's see what examples fall here. First is an employer who, the employee had given all his provident fund to the employer. He misused that funds of the employee. Employer will be guilty of breach of trust because he was a caretaker. Second, here a person belonging, being an employer who deducts the employee's contribution. I deduct the contribution, but I do not deposit it in the with the government. So again, I can be guilty of breach of trust. Next, in breach of trust, again, a executor of a will or a warehouse keeper with whom you had entrusted the property, or you had trusted your agent, all of them can be guilty of breach of trust. So for criminal breach of trust, most important part is the accused must be trusted with the property. The accused must use that property in violation to the direction of law or what as per the legal contract. Clear? So that is it with respect to this part. Then they've repeated just the ingredients. Now let's go to the next, which is cheating. Now when they ask cheating, let's see what it is. Now cheating is given under section 415 to 420. It says in cheating is about fooling someone. You induce a person, deceive a person fraudulently and dishonestly, and you can deceive, fool a person to deliver any money, to deliver any property, or you can sell any fake goods to that person so that so you make him retain certain property, which to get any unlawful benefit or to cause any loss to the other side. So examples of this is when you fool the person that you are falsely pretending to be in civil service. So I falsely say that I am in the army, I am in civil service, and try to take certain benefits. So I am cheating. I put a fake goods. So with the fake goods, I try to sell fake goods. So it will come under the counterfeit goods. Then I pledge diamonds articles knowing that these are not diamonds. Again, this is guilty of cheating. So in cheating, there is a deception and you try to fraudulently and dishonestly induce the person to deliver to you certain things, or to you try to sell him, retain that you keep these goods, these are real diamonds. So this is retaining of property. Impersonation is basically pretending to be someone else. So main you get, it's more than enough. In this thing, it was held at money circulation scheme, that in so many days you can multiply your money, which you know is mathematically impossible. You know it, but you still make all these false representations that the money will be doubled and tripled. This shall be guilty of cheating. Then we go to the next one, which is your forgery. Forgery is about Section 463 of the Indian Penal Code talks about forgery. In forgery, what happens? There is a document or a electronic record or a part of the record. So whoever takes any false document, record, part of the document or record with the intention to cause injury. So if I have forged a signature, so this you have forged the signature. So how do you define it? You have made a false document or a record or a part of the record with the intention to cause damage to someone or to make certain unlawful gain. With the intention to commit fraud commits forgery. Then they give you the punishment for forgery. Now comes definition and the exceptions to defamation. Now defamation means, and it can be of libel and slander. Let's see. Defamation means a false statement made which lowers a person's reputation. So section 499 talks about defamation. Whoever by words, either by spoken or by signs or by visual representation, makes certain comments or statements intent which those statements are false and intends to lower a person's reputation in the minds of right thinking persons, you are committing defamation. Defamation, if I say that uh, in defamations can be of two kinds. One is libel and the other one is slander. Slander is when you make certain statements, so these are just by words, and libel is by in any permanent form, any kind of concrete form. When you made a defamation, for example, you made a cartoon, you made a movie, you made a picture, all of that, you wrote in an article, so this is libel. Slander is just by words that you have made. Obviously libel will have greater penalty and greater seriousness. Then what does not amount to defamation is given under the exception. Now let me tell you a few things which do not amount to defamation. If I am giving someone's track record, a public servant's track record, that he has never come to attend the college, etc., or done XYZ thing, so that is not defamation. Second, if I give an opinion or a review about a book, that is not defamation. If I make a true statement and it is just my mere opinion, it is not defamation. Second, if I publish court record that XYZ person has been accused, it is not defamation. Okay, so then they have given you a genuine criticism is not defamation. So these are all the offenses that can come, and you should know all of them. Okay, so one is criminal conspiracy, two or more persons coming to do a illegal act. Criminal misappropriation of property is nothing but theft. When you trust someone and that person breaks your trust, is criminal breach of trust. Cheating is basically when you have dishonestly or fraudulently deceived or induced someone to deliver something or to retain something which is causing loss to him. It is cheating. So if you give false diamonds saying that it is real diamonds, it's cheating. Then fraudulent deeds and disposition of property. This, in your transfer of property also, you must have done fraudulent transfers. So if I try to fraudulently transfer the property to someone with the intention that the creditors cannot get my property, I have taken a bank loan and all my property, before the default I give it away to someone. So all of that is given here. So fraudulent deeds. Then comes forgery. Forgery is whenever a document has been tampered with to get any benefit or to cause any loss is forgery. And defamation is basically making statements which lower a person in his integrity. Then there are certain general exceptions. The general exceptions. If a person, let's say you have been accused of any kind of crime, you would want to defend yourself. So what are the defenses given? Exception. First, mistake of fact. I did not know only. So, for example, uh, I a police officer was there. He believed that you were the murderer, and he shot you. So it was a mistake. It's not counted. You can take a defense. The person will not be held liable. Second, if the judge wrongly convicts someone and is put in behind jail, later we came to know that person was innocent. So that is a judicial act. Third is an accident. So you had gone in the jungles, and in the jungle you saw that you thought that behind the bushes there is a animal. So you shot the animal, but it turned out that there is a person there. So this is an accident. Next, you did not have any criminal intention. Doctors, if they end up, if they're doing an operation and the person dies, they cannot be held liable because there was never an intention. Next, acts done by consent. So whenever they have these boxing matches, cricket matches, they die. No, uh, no penalty, no imprisonment will be there because there was no intention. It was a consent was being given. Trifling acts, very small little matters, court will not take up the matter. Trifle means very small. And in defense, if you have taken any action, no, this can be done. No case can be done on you if you have in defense you try to do. So this is the chapter. The chapter mostly covers these things only. So introduction, your certain offenses and your defenses. Okay. So we are done with the IPC overview. Now, should we start with CPC? Civil Procedure Code? Yes or no? Can we quickly start with CPC also? Do you want to see the exam questions for this? Let's see. Now, if I put Indian Penal Code. Okay. So this are the exam questions for Indian Penal Code. What all questions have come? So first they have asked, in exceptional cases, mere preparation to commit an offence is punishable under law. Explain. Okay. So first we had seen the 4 stages. The first 2 stages was not punishable. However, there were certain exceptions. So what are those exceptions? If you prepare to make a war against government, you counterfeit coins or stamps, the preparation of it is only there. So these are the exceptions where on preparation itself it will amount to an offence. Having false weights and measures, and committing an preparation to commit dacoity. So in this case, at preparation stage only you can be held liable. Mens rea, we saw that. What do you mean by mens rea? Then in June 19, they are taken, what offence has he done? Okay. So Naveen takes the property of Ganesh out of this in good faith but belonging. So same situation which we had discussed have been there. Now allegations against the accused was that he had furnished a certificate to get employment as a teacher. So in this case also it was there that it was not held of forgery, and it is there in your module also. So the teacher, she just simply said that she was teaching in a school. Ultimately we came to know that the school was not recognized. But since her teaching experience was genuine, it was not held that she was trying to defraud anybody. Next, the Indian Penal Code 1860 provides for certain exceptions for a person accused of committing any offense. So they are giving you certain exceptions which we had seen in the third part of the chapter. So all of that you can write any exceptions. Then in December 2020 they said explain the difference between libel and slander. So in defamation, libel is in permanent form, slander is merely by words. Then a warehouse keeper Now, moment they say warehouse keeper, there was a trust, so it will going to be a criminal breach of trust. In June 2021, they said what is the important forms of mens rea. In mens rea, there is intention, negligence. So all this has been given in the start part, and recklessness. So mens rea means a guilty mind. It can be of different forms. One is you have actual intention to kill someone, you go to stab them. It is called as mens rea. Second is gross negligence. So you had any person of a normal mind would have taken care, but you did not take care. So it is considered to be gross negligence. Your intention is presumed that you are working like this. It is understood only that you will do something wrong. And recklessness is basically driving recklessly or doing something, taking a high amount of risk. People is so these are the different forms of mens rea. Now again, they are saying that managing clerk of a firm of solicitors while acting in the ordinary course of business commits fraud, inducing her to sign the documents transferring the property to him. He had done so without the knowledge. Explain whether the principal will be held liable. This is about Master Stotts chapter. They've explained, they've asked criminal breach of trust explained under section 405. In December, they've asked define criminal conspiracy and the punishment. So we've discussed all of them. If you see, though we went fast, but we focused on the main things which come in the exam. Warehouse keeper has been repeated. Okay, that is it. So we are done with the IPC chapter also. Okay, now we will do the last chapter, which is your civil procedure code. Clear till here? Do you want to do CPC or you want to end it on now? You want to complete a quick revision of CPC as well? Yes or no? Do you want to complete a revision of CPC as well? So whenever I'm covering, though I'm not going in every single detail, but what comes in the exam from exam point of view, including the past exam questions, I'm covering. Okay. Let's do CPC then. So this will be the last part for the day that we'll be doing. We're doing civil procedure code. And also we'll see the exam questions of civil procedure code as well. Civil procedure. Now we're going to start civil procedure code. So very repetitive questions, same and very predictable. Okay. And you'll notice that whichever chapters I have done, those only topics will come in the exam. Okay. So very simple chapter. Civil procedure code. We'll just take a 5-minute break and we'll start. Fine. So quickly, and then we'll do the civil procedure code entirely along with all the past exam questions, and this will be the last topic for the day. Okay, so 5 minutes and I'll be back. Okay, so we'll be starting with your CPC as well and all the important exam point of view. Okay, so let's quickly begin. So my audio is clear, right? So I'm starting with CPC now. Just confirm if I'm audible. You just need to message if I am audible. Quickly. Okay, great. So let's begin with CPC Lesson 8, the Civil Procedure Code. Now, the Civil Procedure Code is a code which regulates the procedure to be followed in civil matters. So it talks about all civil related matters and what will be the procedure for appeal and all those things, summons, etc. Now, first, the very first from exam point of view, they ask the difference between judgment, decree, review. Judgment, order, and decree. So this is the first exam question. I'll tell you what all keeps coming in the exam as well. Okay. First, what do you mean by judgment? So I'd gone to court. So my senior was there. My uncle actually, he told me that what do you mean by judgment? So I said judgment means the order of the court or the decision by the court. He said no. The decision along with the reasons thereof. So judgment under section 2 subsection 9 of the Civil Procedure Code means the statement given by the judges, the actual verdict given by the judgment along with the reasons, and all of this will be based on the decree and the order of the court. Now what is decree and order we will see. First, let's understand what is decree. So judgment is very clear. It's the final decision of the court. Okay, and it is based on a decree and order, and it gives reasons also for passing the judgment. Now what do you mean by decree? In a matter, in a court case, there are no one allegation, there are multiple allegations. So when the court has to determine every single allegation, whenever they decide each allegation, it is called as a decree. So they will say that this allegation XYZ is right. This allegation so and so person is right. So a decree can be given multiple times in a court till the final verdict is given. So the points of contention, the arguments are placed. We have to decide the custody of the child. We have to decide whether it's the child or no. Whether we have to decide whether marriage took place or no. So each matter is to be decided first. So what do you mean by decree? Decree is a formal expression. So of an adjudication. Formal expression means what? Formally in the courtroom, the decree is given. So it's a formal expression of adjudication which conclusively, completely determines the rights of the parties, with respect to all or any of the matters in controversy. So whenever there is a suit, whenever there is a case, there could be multiple controversial facts that needs to be decided. Controversy number 1, controversy number 2 and controversy number 3. Whenever the court conclusively determines the rights of the party with respect to a matter in controversy, it will be called as a decree. Now this can be either preliminary, in the middle stage they can give, or a final decree as well. Clear, simple. So a decree is a formal expression of the court which conclusively means completely determines the rights of the parties with regard to all the matters or some of the matters, and it may be either preliminary or final. Now, in whose favor the decree is given, they are called as decree holders. So they will be really happy because the decree, the one matter when of the case has been decided, to whom, in whose favor it is decided, is called as the decree holder. The one who lost the decree is called as judgment debtor, against whom the decree has been passed. Now let's understand order. In the courtroom, you see multiple orders are passed. Orders bring it on affidavit, order to bring a copy, order not to go abroad. All of this is orders. Order is also formal expression of the court. It is formal expression of the court, but it does not determine the rights of the parties. It is not a decree. It does not determine the rights of the parties. It is a mere procedural aspect. Do not go, get a fresh copy, get it on affidavit, get a new copy, bring XYZ with you. These are all orders of the court. Okay, give your passport, give your employment contract. So these are just simply orders. Now, what is the difference between a decree and order? A decree or an order? A decree conclusively determines the rights of the parties, whereas order does not determine the rights of the parties. Decree can be appealed against. So decree determines the rights of the parties, order doesn't. Decree, since a party has actually won or lost, so he can go in appeal, whereas the order is not determining rights of the parties, so the parties are not normally given right to appeal. So order is not appealable unless permitted by law. Order is given, what you have a problem. It's a simple order, it will not determine the rights of the party. It's just a temporary part to smooth functioning of the case. Okay. Law may provide a second appeal in case of decree. Second appeal in case of is not possible in case of order. Comments and decree you can keep going in appeal, but order is just a procedural thing, so not much rights are given. A decree may either be preliminary or final. Order can't be preliminary, it is always final. Order is said, go and get it. Now what is a preliminary or that? Nothing in that. Interlocutory orders. Interlocutory orders is whenever there is in case of perishable goods. Perishable goods. So whenever we feel that goods can perish, so that time we say that order interim sale of the goods. Now party A is saying it is their goods, party B is saying their goods. During that time that goods can become spoiled, so we will say sell the goods, get the money, whoever wins the case we'll give it to them. So this is an interlocutory order, an interim sale, take the money and then later we can give whoever wins the case. Now cause of action. Whenever you go to the court, there is some reason you went to the court. There must be some cause of action, reason that you have gone to the court. So ideally you will have to prove that you had a right. You first have to prove that you have a right, and then you have to show how that right was violated. So I will say the contract was breached. So first I have to prove that there was a contract, and then I have to prove that how it was breached. So this is the cause of action. Now, jurisdiction of the court. Jurisdiction means the power of a court to entertain a matter. Now, jurisdiction means the power of a authority to give justice. Now, jurisdiction powers can be of different things. One can be subject matter. For example, we have consumer courts. So, only jurisdiction means only consumer matters can come. Labor court, only labor matters can go. Family court, only family matters can go. So the court jurisdiction is based on subject matter. Territorial jurisdiction. Territorial jurisdiction is with respect to the area. So we can say that in this district court only this much matters can come. Another area it is there, then that court will handle. So the jurisdiction is territorial in nature. We've seen so many times, we have police stations, it has only power till certain rights, till certain area. Jurisdiction over persons. So we saw jurisdiction over subject matter, over territorial jurisdiction. Now we're seeing jurisdiction over persons. Now jurisdiction over persons means like the precedent cannot be tried in a lower court. So they have also said what is there. So over persons, so depending on who they are, courts can sometimes determine their jurisdiction. Pecuniary jurisdiction is monetary. Pecuniary means what? Monetary. For example, we've seen in small causes court only up till 50,000 matter will go. Above that it will go in the High Court. Same way in we have consumer forums. So the pecuniary jurisdiction is given to take up the matter. Okay. Then important, very important. I want all of you to learn it with me. This can come in your exam. Section number 10 and section number 11. Section number 10 is res sub judice and the other one is res judicata. Understand what is res sub judice. If a matter is pending in one court in India, you think other courts can also take up such matters, such the same matter. If a matter is pending in, let's say, Bombay High Court, the party files same matter when this matter is pending in Gujarat High Court. Should Gujarat High Court take the matter? Answer is no. Gujarat High Court will say that the doctrine of res sub judice applies to me. That I cannot take up the matter because there is another court of a competent jurisdiction taking up the matter. वो खुद कोर्ट उठा रहे तो इधर क्यों आ रहे हो? Multiplicity of cases क्यों कर रहे हो? इधर और उधर एक तो already burden of cases है. Already there are so many cases in India. Why are you bringing so many multiple cases? So if matter is pending in one court, no other court will take up the matter. Section number 10 says stay. उधर है ना, रहने दो. It is there, let it be. Stay of suit. No court shall proceed with a trial of any suit in which the matter in issue with the dispute is directly and substantially in issue in a previously instituted suit. The matter is in issue in another suit between the same parties are fighting and the same title. So plaintiff defendant, वहाँ पे भी plaintiff defendant. Normally what happens, the party likes to harass. I will file a case here also. On the same thing, I'll go you there also. Then I'll go in another court just to harass the other side. So this res sub judice says that if a matter is pending before one court of competent jurisdiction, other courts in India shouldn't entertain. And where it is pending in some court in India having jurisdiction to grant the relief, then the court should not, the second court or the other court should not proceed with the trial. Clear till here? So what are the essential conditions? There has to be two suits. One suit filed at different times. Matter in issue in the later suit is also in issue in the earlier suit. The same matter जो अभी आया है वो पहले भी हो ही चुका है. Suit should be between the same parties and the earlier suit is still pending. So that suit is still pending and you've come here, so that is not allowed. Clear till here? However, if it is pending before a foreign court, then you can still do. Now, res judicata. Now, section 10, supremely important. One matter is pending, then in one competent court in India, other courts in India will say we will not take it up. Let's see res judicata. Res judicata, section number 11. Section 11 says res judicata. Cata means, just you can remember, to bite. Because लोग confuse हो जाते हैं. Res sub judice और res judicata. Sub judice is stay of suit, section 10. Judicata, cata means to cut, to bite. So just remember, no person can be vexed, punished twice for the same offense. So no person's res judicata means no person, अगर एक के ऊपर केस हो चुका है, if there is a case on one person, let's say for one offense I am done, I have served my punishment and I have come back, can for the same thing, same matter, I have not done anything new, for the same old matter only you will file again case. So then they say नहीं एक बार परेशान किया, once you cut him ना बस, now again you can't do. So you cannot file a case which has already been decided and the verdict been given and the person punished again in another court at another time. Why? Because it's already been decided. No person can be harassed twice for the same offense. So deals with the doctrine of res judicata. a bar on restraint on repetition of case. You filed it once, now out of again and again he keeps filing. It is a pragmatic principle that there must be a limit or an end to issues. The doctrine says no person shall be vexed twice for the same cause. For the same wrong, you cannot be punished twice. It prevents two different decrees on the same subjects. Now, what does it say? The language, okay? Pay attention. If a suit has been filed now, but the same matter between the same parties has earlier been decided and disposed of and punished. So then the second court should not take up the matter saying res judicata, he has been punished once, he cannot be punished again. So the matter which is directly and substantially in issue in a former suit is also in issue in the current suit, later suit. The former suit is decided. The issues have been heard and finally decided. Then such former suit and later suit are between the same parties litigating under the same title. So it says, in short, the principle says that where an issue has been raised in a subsequent suit was directly and substantially in issue in a former suit between the same parties and heard and finally decided, then the second matter should not be taken up. Just a second. Okay. So what are the conditions of res judicata? Same language you have to learn. The matter is directly and substantially in issue in both the suits are the same. It is between the same parties litigating under the same title. The earlier court has decided the case and the same question is also there. So the second suit, the second court will not take up the matter. Difference between section res sub judice and res judicata. Res sub judice is section number 10. Res judicata is section number 11. Sub judice says stay of suits, matter is pending. Here the matter is already decided and heard and disposed of. So now, then comes to the next most repeatedly asked question for this as well, which is your set off, counterclaim and equitable set off. So they say answer this. First, let's see what is set off, counterclaim and equitable set off. Now set off is what? Very simple. It is in first I'll give you the legal language of it. It is reciprocal acquittal of claims. Reciprocal acquittal of claims. Your claims are set off against my claims and only the balance is paid. You had to pay me 1 lakh, I had to pay you 75,000. So 75,000 will be set off and decision will be given that you pay me 25,000. That is set off. Reciprocal acquittal of claims, where the plaintiff's claim is set off against the defendant's claim and the order is given for the balance amount. So set off is reciprocal acquittal of claims. It has the effect of extinguishing the plaintiff's claim to the extent of the amount claimed by the defendant. A claims 1 lakh and B claims 25,000 and let's say it has been proved correct. So court will order 25,000 will be set off and order will be asked to pay for 75,000 only. Now this is set off where monetary amounts are set off against each other, both are claiming against each other. Now counter claim is a claim in addition to set off that you are making. For example, I will say that he has caused me loss of business and opportunity. This was one matter where you were claiming against me. I say because of you, I almost like filing a separate suit. So counterclaim is much more vast. I make a counterclaim such a way that I become almost like the plaintiff and you become the defendant. So if I have filed allegations on you, so the plaintiff made allegations on the defendant. The defendant went to his lawyers and he said, now we will make a counterclaim where we will put our claims in such a way that he might have to come and pay. अभी उसको भरना पड़ेगा. So we put him only in the back foot. This is a counterclaim. So how do they say it? In addition to set off, a counterclaim can be made against the plaintiff. It is a reverse claim. लेने के देने पड़ गए वैसा हो गया. I filed a case to claim 1 lakh और उल्टा उसने counter claim किया. Now I have to pay 25,000. So it's a reverse claim by one party against another, where it will be heard in the same proceedings. Equitable set-off is a type of set-off in which it is for set-off of uncertain sum of money. So there are types of set-off. Equitable set-off is one of them, where the defendant is claiming money. Let's say the plaintiff is asking, I have to pay him 1 lakh. Defendant is saying कि मेरे को भी, he also has to pay me some money. I don't know exact amount, how much. So when a defendant is claiming set off, but he doesn't know exact amount, uncertain sum of money, that is called as equitable set off. In India, distinction between legal and equitable set off is recognized. In England, it is not. Clear? So set off, counterclaim, and equitable set off. Now coming to temporary injunction. Very good. So temporary injunction means what? Temporary injunction. Injunction is basically a order of the court. Injunction is nothing but a order of court. Either asking a person to do something or not to do something. Not to do something. Now this injunctions can be of two kinds. Injunction could be of two kinds. One is temporary injunction and the other one, so injunction, what did I tell you? It's an order of court asking the party to do or not to do something. Okay. Temporary injunction, and I can say the other one is permanent or perpetual. Permanent injunction. Temporary injunction is basically during the pendency of the suit, during the case. This is at end of case. Means if you are saying this one is also fighting, that one is also fighting. So the court will say, see, till the final disposal of the case, you deposit all those goods with me. This is a temporary injunction till the final disposal of the case. Once the court has been decided, once the decision has been decided, then a final verdict can be given. Let me give you an example. A builder is there. He is making illegal construction. He is making illegal construction. I immediately go and file a case and put a temporary injunction that to prohibit him from making more goods, to make anything more or do any more construction till the final case. So then we will say, okay, fine. Your court will pass an order on basis of prima facie evidence. So whatever is there superficially, the court will say, okay, fine, the builder looks wrong, we will prohibit him till the pendency of the case. Then after hearing both the sides, after detailed arguments, then the court decide detailed evidence. Court found out that the builder was wrong. It will permanently prohibit him from constructing anything. So that is a permanent injunction. Clear? Injunction is nothing but an order of court ordering a party to do or not to do something. This is also important. It has come many times in the exam. Now, temporary injunction could also be till the final case: do not sell off the property, do not alienate the property, do not damage the property. That all they have given here. Then, next is about summons and delivery of summons. Just like as we had seen, whenever the court wants to call someone, it is called as a summons. They will call the person, they can call the document, they can call anything. That's a summons. But if the party does not come, then another summons has been given. Summons will be there is certain service of summons is very very important. If the person is not taking the summons, then it will be stuck somewhere, etc. Then comes to the next and the most important part of the chapter again, the last part which definitely comes, okay, which is your reference review revision, okay. So stay with me, supremely important. Reference section 113, reviews 114, and review revision is 115. First, what do you mean by reference? Reference is basically when a lower court is not understanding something. As you sometimes don't understand, you ask your seniors. Yes or no? If you don't understand something, you ask your seniors. Same way, here if you don't understand something, the lower court doesn't understand something, they can refer the matter to the High Court for its opinion. So at any time before the judgment of a court, a court may state a case and refer the same for the opinion of the High Court. And then the High Court can pass any order as it deems fit. Review 114. It is like revaluation of your paper. Do you make it to another authority or same authority? Revaluation. Revaluation is given to the same authority to reconsider, recheck. So I make an application to the same court to reconsider or recheck the application. Here they will only recheck and reconsider if now court will. Why will they do? I have passed a decision. You're coming back and telling एक बार वापस check कर लो decision. I will say why will I check it again? So they will say you check. Court will only review the thing अगर उनका mood हुआ तो. Now what is mood? If there is a mistake apparent on face of record, any other reason which it deems fit, or a discovery of a new fact which was not known at the time of passing the judgment. So if I didn't know exactly at the time of passing the judgment any fact, so then I passed the judgment accordingly. But then later the party came that see new evidence has come, please reconsider your judgment. Then I will rescind it. Then comes revision. So reference, review, revision. Revision is something like certiorari for writs, where the higher court calls for the record of a lower court and they see, lower court has exceeded the jurisdiction or taken passed a judgment on which has no jurisdiction. So the higher court will call the lower court and ask for the records. And when they find that you have done something wrong, they will squash it, set it aside and pass the new judgment. So revision is to revise, change the judgment of a lower court which has exceeded its jurisdiction or passed a erroneous judgment. Okay, so the High Court will call for the records of any case, decided by a court subordinate to it. If according to the High Court it feels that lower court has not exercised its jurisdiction correctly or has failed to exercise, or as there is some material main irregularity going on. Suits by or against minors. This also once they had asked. Now, first, a minor person is a person who is not completed 18 years, but if it is with the court of wards, where the courts are taking care, then the age is 21 years for majority. So any person in court of wards is below the age of 21 will be a minor. Now, if a minor is there, for him, a guardian will file a suit called as the next best friend. When the minor attains majority, he can tell the guardian, now I will take over the matter, or I can release the guardian, or I can let the guardian continue. Okay. Then they said, what are the remedies available for the defendant against whom a ex parte judgment has been passed? So ex parte order means if I have not gone to court and in the presence. So revision is about not facts of the case. It could be a judgment which is wrongly passed to which no appeal lies. When someone has asked, can you explain revision again? So understand what is revision. There is a lower court. That lower court has passed a wrong judgment. And in law it is written that lower court, there is no further appeal. The appeal is not there. So then we will say now they can't even come in appeal and the wrong judgment has been passed. So the High Court, as per Article 227, has a superintendence of all the lower courts. Whenever they feel any wrong judgment has been passed and there is no other remedy, then they will call for the records and they will set aside and pass the correct judgment. Now let's understand what is ex parte order, ex parte decree. So ex parte is when a decision passed in the presence of one party only is called as a ex parte decree. In presence of one only we pass. The other party did not come, so we will pass the judgment. Now the party came to know that the judgment has been passed against him, और वो तो गया ही नहीं क्योंकि वो बाहर होगा, he did not come. He can go in appeal against the order of that ex parte judgment. So in a civil case, a defendant has 4 remedies if a ex parte order has been passed against him. So he was not heard only and decision was passed against him. Maybe he was changed his location or was abroad and order was passed against him. He can file an appeal against the ex parte order under section 96. He may file a reviewed for that same court only. They will tell you please reconsider your matter. He may apply for setting aside of ex parte order, and a suit can also be filed to set aside an ex parte order obtained by fraud, but no suit shall lie for non-service of summons. So if there is a fraud, then a separate suit only can be filed by him. Ex parte order means what? Plaintiff filed a case, summons was given to the defendant, but the defendant for some reason was out of India. Court did not know. Court feels that he is not coming because he has no defense. And time passed and order came against him. When he came back into India, he realized that an ex parte order is there. So he has all these 4 remedies. Then comes summary procedure. Again, summary procedure is speedy settlement of disputes. Only these kind of matters, suits such as bill of exchange, hundis, promissory notes, where it is very clear that it is a clear cut case, can be summarily tried. मतलब अगर bill of exchange है, everything is clear and we came to know that the party did not pay you, dishonor हो गया bill of exchange. So such matters can be quickly settled by the court where everything is so clear. So court gives the defendant 10 days. The defendant is not entitled to defend the case unless he appears within 10 days from service of summons. If he has not come within 10 days, then the order will be passed against him and he will not get a permission to defend his case. Summary suit must be brought in within 1 year from the date on which the debt becomes due and payable. So आज अगर bill of exchange due हुआ, within 1 year the party has to file for summary suit. Clear till here? So we are done with the civil procedure code also and everything. Let's see, I'll show you the exam question. All we have covered. First is res sub judice. Please mention the section number. Res judicata and res sub judice. This much you all can do. Section number please. So section number 10 res sub judice, section number 11, res judicata. Then what are the remedies against whom a ex parte order is there? We saw there were 4 remedies. What all he can do? Distinguish between review and revision. I told you reference, review, revision. 3 important things. Can you tell me the section? Section 114, 115, 113, 14, 15. Very good. Mention it. Reference 113, review is 114, and revision is under section 115. Then came courts has the power to grant temporary injunction. Temporary, define what is injunction. What do you mean by temporary injunction? Then summary procedure. Again we saw what is summary procedure. Leave to defend. The person will get maximum 10 days to defend himself. Otherwise order will be passed against him. Res judicata and res sub judice. Again it has been repeated. Very important. December 2019. What is set off and counterclaim? Again it has been told. Decree. What is decree? Defined. So all the conditions have been given. So just see the answers. We have covered everything in detail. Elaborate the provisions with respect to suit against minor and what will be the impact after he attains majority. So we'll explain what is the suit against minor, and we'll say after majority he can choose to continue, or the guardian can continue if he wants, or the minor will tell the guardian that I will only handle the matter. In June 2021, they've asked whether in case of consent and compromise decree between the parties, principle of res judicata shall apply. So whether in case of consent, okay, so it will apply. So section 11 says the doctrine of res judicata, no one shall be vexed twice. However, it does not apply in case of consent and compromise between the party, but depends on the court subject to the facts of the case. So a consent or a compromise is not a decision of the court. So if the parties had some consent, doesn't mean that he has been vexed. उसको तो punishment मिला ही नहीं है. So does it apply? Answer is no. What is temporary injunction? Again it has been repeated. In December 2021, discuss the provisions of CPC which provides multiplicity of suits in respect of the same cause of action. So section number 11, temporary injunction. Again it has been repeated. What are the placing of suit under section 16? So again, whenever a suit is there, it should first be filed in the lowest court. That is what they have given in the correct jurisdiction, and that is it. The entire CPC is also over. Okay, so I am done for today. I'm not going to take in more time. You all have to do your self study as well. Okay, so that is it. Please subscribe to the hit the bell icon on the YouTube channel if you find our channel relevant and you find it helpful, because I will be coming in more marathons for the other subjects, especially GST and all the others. GST is a very beautifully also I've covered. This time I will be taking. Okay, nice. So that is it. I hope you all liked it. Wish you all the very best. JIGL, you can score really well. The past exam questions are repeated so frequently. Don't worry at all. Write the entire paper, write it well. That is it. Okay. Keep a positive mind. It's your first paper. It's going to be very easy. That is it from my end. Thank you so much for your patience. You can individually search it with the name. Okay. Thank you so much. Good luck. Please study hard. Okay. Thank you. And also this was one of the most responsive lectures, and I felt really happy to see so many people. I get more and more motivated to serve you all much better. All the very best. Take care.